Pilot Mr. Tapin is unwell today. So item number 1, can it be taken up next Monday?
Next Monday.
Yes, ma'am.
Who is for the petitioner?
Petitioner is on
I'm
GC.
appearing. I'm appearing, my lord.
Yes. So there is a pair from the Additional Advocate General
My
for
lord.
taking up the matter on next Monday.
What is the date? Just, can I just take 1 minute for your lordships?
Yes.
Then- Can it be on Tuesday, my lords, not the 16th? Tuesday.
Yes. Yes. Okay. On the pair being made by
17th.
Mr. Roton, Learned Additional Advocate General.
18th, my lords, 18th if possible.
18th.
My lords.
Okay. Dismissal is the matter on 18th.
Obligation. My lord, and item number 2, I was supposed to furnish a status report. My lord, can this be taken up as the last item? The officer is on the way, ma'am.
Okay.
Obligation.
Where, my lord? My lord, I beg to mention item number 4, my lord.
Item
Number 4, my lord.
4.
Yes. My lord, this matter was supposed to listed on 9th of January, my lord. This is wrongly listed, my lord. So, my lord, on 9th January, my lord.
9/11.
January
9/1.
9/1.
Yes, 9/1.
Okay. Okay. SSL is the matter on 9/1/2025.
My lord, let me direct the registry to reflect my name for the
You are appearing for
private respondent.
private respondent. Mr. D. Panging, Learned Counsel for the private respondent number.
My lord,
Private
this is my name was not reflected even get the brief.
5 to private respondent.
All the private respondent.
5 to 34 or something.
Uh,
24, I believe.
24.
in the cause list, SSL reflect the name of Mr. Panging, Learned Counsel for the private respondent in the cause list.
Obliged.
My lordship, I beg to mention item number 7. This matter is listed on 12th of this month.
12.
Yes.
Ms. So-and-so, Learned Counsel for the appellant.
Yes, ma'am.
Press for missing that you inform the other, Mr. Parmish, any objection? No. With consent from the other side, press for listing the matter on 12. 12. Here.
May your lordship, this IE application is being filed for impleting Union of India, your lordship, in connected treat appeal.
Union of India to be represented by?
Your lordship,
To be represented by?
that is being represented by there's a standing council, DSGI. Party is represented by Ministry of MHRD, your lordship. Ministry Human Resource Development.
Yes, respondent number 9.
Yes, your lordship.
Yes, Mr. Pangay, any objection?
No.
No. Heard Ms. Ondu, Learned Counsel for the applicant, then Mr. D. Panging for the respondents. For all the respondents?
Private respondent.
Private respondent. And Mr. Kato,
Number 9.
respondent number
9.
9. This interlocutory application is referred by the applicant for implementing the Union of India as respondent number 9 in this petition. Mr. Panging, Learned Counsel for the respondent, submits that he has no objection in the event of implementing the Union of India as respondent number 9 in the writ appeal. Having heard the submission of learned advocates of both the parties, we have carefully gone to the petition and the documents plus on the record. And we find that Union of India is a necessary party in the database. And therefore, this court is inclined to allow this application. Rest shall do the needful in this regard. In main appeal, you will take down hard instance. Learned counsel for the appellant and Mr. Pangling, learned counsel for the respondent members and Mr. Kato for respondent number 9. When can it be listed?
Not any date, but this is no, how is the appeal maintainable, my lord? It was passed on their submission.
No, are you ready to hear?
After 2 weeks, your lordship. After 2 weeks,
After 2 weeks.
lordship,
2 days.
2 weeks.
Two.
Madam, 4 weeks time may be granted. In the meantime, madam, I take instruction from the ministry, madam.
Acha.
Since, madam, this is a conflict, madam, the issue is between the Neris and the, madam, the. ministry.
Union of India, I believe, did not even file an affidavit during the proceedings, my lord. Why now?
Not even challenge the earlier order.
No.
However, madam, the instruction, madam, the student.
Let it be,
No, sort that 2 weeks.
my lord. Otherwise, my lord.
Madam, in that case, technically, madam, the Union of India is also, madam, the petitioner, respondent, madam. The same respondent, madam. So therefore, madam, there is no requirement of the filing separate affidavit. It has to be filed through the Neris, madam.
That was done.
So therefore now.
Mr. Kato, learned counsel
There
for
is-
respondent number 9
Versus, madam, the Union of India.
submits that the matter may be listed after 2 weeks so as to enable him to obtain necessary instruction. That is according to the law, shall list the matter after 2 weeks.
Declare.
Deeply acknowledged.
Review petition to main proceeding on a party PI increase person. So eight party increase the review.
Who is for the petitioner?
Yes. We can do case page 12, internal page 12, second paragraph. Original landowner association. Order to page 12.
Anybody for the petitioner?
No, madam.
None appears for the petitioner on call. How about Mr. Mr. Kamdo
Yes.
and Ms. Basar and Mr. Tagum? For the respondent number?
My lord.
1646. And Madam Basar?
One, 4, 5, 6, 8, 9, 10.
And Mr. Kamdo?
For my lord, respondent number 2. Yes, my lord.
Present. List the matter after 2 weeks. In the event of subsequent non-representation, appropriate orders shall follow. Non-representation of the petition.
Item number 6.
May I please, Lordship? Lordship, in this matter, Lordship, service matter has not been completed, service has not completed for respondent number 34, 36, and 37, Lordship. Kindly allow us to take steps, Lordship.
So in respect of 37, you have to obtain instruction
Lordship,
because in the earlier days, service could not be effected. Pardon me, your good name?
We would have-
On behalf of Mrs. A. Gandhi.
We would have considered, my lordship. We would have considered, we're the main party in the appeal.
That's it.
They were co-respondents actually in the writ petition. Instead of lengthening the proceeding. Because what they have prayed for in the appeal is something that we are not agree with. Anyways, lordship, that's up to you, lordship, of course.
Third, Ms. So learned counsel for the appellant. Then Ms. Dangan for respondent number
1 to 33.
1 to 33.
Yes.
And you? And Mr. Kangdo?
It would 35, 36. Cut.
39 and 40.
39 and 40.
Yes, madam.
Okay. Okay.
34, 35, 37. Page 18 of the process. Full of a comment. Page 18.
Lordship, since the appeal is limited only to the extent of, extent of directing the deputy commissioner a question of interest. That's why I'm saying we will concede on this point.
Don't.
Lordship,
You're not claiming.
Lordship,
You're not claiming interest.
Lordship, because we know that it will take such a long time. We are, I have instructions to concede on this point. The rest
File
of
an affidavit on the extent
of like,
placing the instruction on the-
Lordship.
Office note dated 7/12/2024 indicates that unserved notice in respect of respondent number 37 returned to the registry. And service report in respect of respondent number 34 and 36 are still awaited. The learned counsel for the appellant submits that she may be granted 2 weeks' time to take fast step upon the aforementioned respondents. Where is accordingly allowed, rest shall list the matter after 4 weeks. Mr. Kato, can you represent the
Chief of Army Staff. 34. Chief of Army Staff. Chief of Army Staff. General Officer commanding 56 infantry. And commanding officer 8 Maratha. You can.
serve one copy to him?
Yes.
Leading.
Later on, Mr. M. Kato, learned counsel, appearing on behalf of respondent number 34, 36 and 37 submits that he will accept notice on behalf of the aforementioned respondents. Accordingly, it is provided that the learned counsel for the petitioner shall furnish a copy of the memo of appeal to Mr. Kato during the course of the day. Place the matter after
Service complete.
service complete. In view of above, service is completed and SSL is the matter after. When?
4 weeks. Madam.
4 weeks.
Deeply pleasure.
Paper book. I guess at the end.
My lordship. Lordship,
Ready to argue the matter?
Yes.
Yes, Mr. Pandey?
Yes, my lord. In fact, if your lordship sees two deposition, there is no question of allowing the appeal.
Lordship,
5
question
minutes, no question of allowing the appeal, man. The doctor's report and PW1 and the medical report.
Okay, let him argue then.
Yes.
Lordship, the basic question, Lordship raised in this appeal is Lordship, the accused person has filed an application
Hmm.
for defense evidence. For defense evidence under 315 of the CRPC. Kindly see this, my application is not in the paper book, but I have enclosed. There was some serious lapses during the course of trial. Kindly see.
Is it part of the memo of appeal,
No,
that petition?
in my petition, there is there, but in the paper book, it is not published.
No, may not be, but in your memo of appeal, it is there
Yes,
at page number?
at page number, kindly see. Section will be run for, page number 53, 53. This is the 53 annexure 10. This is the application under 315 of the CRPC, praying for defense witness in the instant case, in which there was a two defense witness, in which one of the this witnesses, defense witness was put that the convict himself, Pange Pansa.
Hmm.
But one of the, after taking Kamge Pansa, the second defense witnesses, the court didn't recorded this defense witness.
Court did not?
Didn't recorded this defense witness. He has not taken, court has not taken the,
No,
defense
whether
witness.
any order was passed upon this petition?
No any order pass. No any order pass, except that after recording the defense witness of the witness, defense witness number 2.
Hmm.
That is why the convict could not properly defend his case before the trial court.
You took exam in correlation. Only one bullet, DW one bullet exam in correlation, second took. How does the whole park exam in correlation? Accused. I can do 313. 313 solution. Into part. Witness evidence exam. Who's on this? Coming from the problem.
Second.
Second to alien, they accused to question the law with no evidence in.
Lordship, as per 315 under the proviso, Lordship, the accused is one, accused may be a competent witness to defend his case.
Yes, yes.
That is a right.
Mr. Soma, this is
Statutory right.
CRPC.
That has to be there.
CRPC.
Memo of appeal nahi. Record I said.
Accused to lower swallow the Guna Bukuri. Accused of the person to Napa, Korea, John was there.
May I read that contents of 315, language of the 315. The language of the 315 says, any accused.
No, that's all right.
Yes.
But
That is one of the ground, basic ground, and
what
another
is
ground
the
is.
trial court record? On who is that you have filed that petition?
Lordship,
Page number 51?
Lordship, that is not mentioned, but kindly see this order, conviction order. Conviction order in the page number, kindly see page number 78 of my this appeal. That is page number 78 of my appeal. This is the conviction order. The list of prosecution, defense witness and court witnesses. Kindly see one of the defense witness has been recorded as defense witnesses, which I have filed along with my name. But the court has not recorded the accused as a defense witness. Page number 74. There is a serious lapses in the constitutional code.
Yes, madam, have you gone through the record?
My lord, I am sorry, my lord, the memo, I was furnished only with the paper book. The memo of appeal was not there. I've just come to know. Let me
Appeal
check.
memo
Yes, memo of appeal was not furnished.
to you.
Yes, only the paper book was furnished, so that was, I was not aware of this. We have to check the records, my lord.
Yes.
This
Where?
application at page 53 is neither dated, I don't know how. Because there has to be some order sheet, my lord, on this.
Definitely.
Yes.
Should we defer the matter then today?
Yes, my lord, I have to check the order sheet.
Suggested that then Wednesday?
My lord. My lord.
As agreed by learned advocates of both the parties, the rest is the matter on Wednesday. In the meantime, Mr. Tapak, you furnish a copy of the memo of appeal to Mr. Pangeng. Mr. Pangeng, learned counsel for the respondent, submits that he has not been furnished with a copy of the memo of appeal. Mr. Tapak submits that he will furnish a copy of the memo of appeal to Mr. Pangeng during the course of the day. This is the matter of Wednesday.
Can this matter refix on 18? 18. 1/8.
1/8.
Yes, 1/8. For disposal.
18.
Yes.
Okay. 18.
On the last occasion, I was directed to furnish a status report. Status report arrived. I asked for xerox of that copy. Only one copy was available. Status report, what I've seen is formation cutting has been done, and there are culverts to be constructed. That has it's going on. So just what is it? Xerox no matter. I think not only Xerox, there's status report in order. This is also part of the last report.
No, we have it.
Before execution and geotech.
Furnish a copy to him also.
Yes, my lord. Otherwise, I believe that PIL is not premature
Premature.
because there is still time left for completion. And if the contractor does not complete the work within the time frame, then they can come. Otherwise, keeping this pending.
Decca?
My lord, actually, the formation cutting was not starting from the 0 point Tabiar. It's a 5.22 kilometer length road, including 13 numbers of culvert, 20 meters bailey bridge, etc. But where the formation cutting is going on, we have not seen. We are for society only. This project itself is a blessing for the people of the locality, but they have not done so. So,
No,
the
time is
report-
till 2026.
2026.
Then
actually, we should satisfy with report. Report may be directed to give us also.
why?
Because actually, what is the black and white? In the side, there is not like that. This is black and white report only. So if road is constructed, we are very happy. Will be satisfied enough because this road will communicate the backward people to the city for business, for everything.
If the contractor fails to carry out the work within the stipulated period, only then you can approach the court. Is it not premature at this stage? Then as per this report, they have already started formation cutting.
My lord, if there is no court proceeding, then there is no hope of completing this. They are starting from midway, might be, because from not n point 0 point Tabiar to n point Yangte. And they are starting the formation cutting from the other places only by deviating the
No,
DPR
it
road.
is their prerogative from which point they will start.
Yes. They should start from 0 point Tabiar.
Hmm.
But from the 0 point Tabiar, there is no trace of formation cutting till that.
You better withdraw this PIR.
Liberty.
We grant you liberty to approach this court again at appropriate time.
Yes, ma'am.
Yes.
Not that this is there.
Yes. If the construction would not be done as per DPR, then
Yes.
we may have liberty to
Yes,
again
yes.
approach before this on
Yes, yes.
because this road is a blessing of the locality, my lord.
Yes, yes.
Yes.
Heard Mr. Yu Decker, learned counsel for the petitioner. Then Mr. N. Roton, learned additional advocate general for the state respondents. Pursuant to order of this court dated 4/12/2024, Mr. Roton, learned additional advocate general has produced before this court a report from the respondent authorities. Look, some pictures are enclosed here with the report. Is it not the?
This is not the project side, another side.
How can they?
Let's see.
How can,
Mr. Roton,
how can this be? We have just,
Because in the 0 point, they said that here Tabiar, the 0 point Tabiar, no such like cutting is going on, my lord. Okay, so we may be given liberty if not completed as per DPR. If they are constructing the road as per DPR, it's a very good for the common people for communication and transportation.
no, they have already started formation cutting. Definitely they will carry out. Keep on the line. We have perused the report. So produced before the court by Mr. Rotom. And it appears that the contractor has already started some work. At this instance, Mr. Deca, learned counsel for the petitioner submits that he may be granted, no, he may be permitted to withdraw this PIL and to approach this court again as and when required. We find sufficient ground to permit Mr. Deca to withdraw this petition. However, liberty will remain with him to approach this court again by filing a appropriate petition.
Obliged.
Obliged.
So then item number 3, we have filed an additional affidavit. Your Lordship may allow me to call it on record.
Additional.
Lordship, I would like to mention item number 9, Your Lordship. May I kindly take up this matter on 7 January. I've taken the consent of the petitioner, Your Lordship.
Item number 9,
Yes, Your Lordship.
you are appearing
For the state respondent 1 and 2.
1 and 2. Ms. Arbasar, learned government advocate, appearing on behalf of respondent number 1 and 2 with consent from the other side.
Yes,
From
Lord.
the other side.
Yes,
Press for listing the matter on
7th
7th of
January.
2024. Here is according to the
Obliged, Your Lordship.
Yes, my lord. I beg to mention item number 10, my lord.
Yes.
Here, my lord, I have supposed to file some additional affidavit, my lord. I have received the instruction, my lord. I have informed the petitioner, my lord. May I pray this be listed next week, my lord?
Mr. L. Parme, learned counsel for the respondent with consent from the other side, press for listing the matter on
Next week, my lord.
next Monday.
No, my lord. Wednesday, my lord. Yeah, Wednesday. 18, my lord.
18.
18, my lord.
Fair, Lord. Yes.
Obliged.
May I please, my lord? My lord, I beg to mention item number 21 and 22, my lord. On behalf of Hawaii Doloi, my lord.
On behalf of
Hawaii Doloi, my lord.
why?
Hawaii Doloi, my lord. He is a Guwahati-based advocate, my lord. He is unable to appear today, my lord. So kindly matter
You
maybe.
from the other side.
Yes, my lord.
Mr. Your good name, please.
M. Doji, my lord.
M. Doze, learned counsel appearing on behalf of Mr. Y. Doloy, learned counsel for the respondent. Press for listing the matter after
My lord, can it be on 19 of this month? my lord?
19.
Yes.
Fair.
Obliged.
May my lordship, I beg to mention item number 17, my lordship. This matter may be listed day after tomorrow.
So learned counsel for the respondent authorities, press for listing the matter. You informed the, yes, madam? Yes. No, objection. No. With consent from the other side, press for listing the matter on
Day after tomorrow.
day after. Fair.
May I, Lordship? Lordship, I beg to mention item number 4 and 5. Lordship. Here the conducting counsel is Mr. P.D. Nair. Due to some unfortunate circumstances, he couldn't appear, Lordship. And this is for motion. Kindly, Lordship, may kindly fix this matter on 16th of December.
16.
Yes, Lordship.
Your good name?
T. Gyatsol.
T. Gets so learned counsel for the petitioner with consent from the other side, press for listing the matter on 16. Fair.
This contempt petition is filed against the contender for non-compliance of the order dated 13/3/2024 of this honorable court, which is passed in WPC number 632 of 23. The order is annexed in page number 12, Your Lordship. Page number 12, para 7. Whereby the petitioner has been granted a liberty to file an appropriate application for her service to be effect from retrospective effect. And accordingly, petitioner has been filed the application before the authority on 18 March 24, but till date the a contender has not been taken any step, Your Lordship, and it's been since.
Okay, let notice go at this.
Yes,
Your
yes.
good name, please.
Tirimi.
Hard name, so learned counsel for the petitioner. This petition under Article 215 of the Constitution of India, read with Section 11 and 12 of the Contempt of Court Act 1971. And the Contempt of Court Rule. Contempt of Courts, which indicate Guwahati High Court Rules 1977, is referred by the petitioner, Ms. Sonal Dubey, for willful and deliberate violation of the judgment and order dated 13/3/2024, passed by this court in WPC number 632 AP 2023. Whereas the petition, the documents placed on record and the order dated 13/3/2024, passed by this court in WPC number so and so. Let notice be so to the contender, returnable in 4 weeks, step be taken by the start post with AD and also by usual process within a week from today.
Your Lordship, I may be allowed to take justice service since the office of the contender is nearby to our chamber. Your
In
Lordship.
addition to above, justice service is also permitted. List the matter after 2 weeks then.
Yes, Your Lordship. God bless Your Lordship.
Number 2. My lord, item number 2, can it be possible for the timing, my lord? I have received the instruction from the department. I have asked my junior to get a Xerox, my lord. Just possible for the timing, my lord. Oblige.
Additional.
May please, Your Lordship. Well, this matter has been, in fact, wrongly listed in under motion column. Notice was issued on the last occasion. If Your Lordship kindly sees the order dated 19/11/2024. Issue notice returnable in 2 weeks' time. Second paragraph. Anyway, my lord, that is that nomenclature under which it has come is not important. If I'd like to draw Your Lordship's attention to the first order dated 12th of November. There is a, my lord, reasoned order granting some interim relief. And if Your Lordship kindly comes to the, my lord, paragraph 9, considering the submission made by the learned counsel for both the sides, in the interest of justice, the operation of the impugned letter dated such and such, signed on such and such, and the impugned order dated 8/10/2004 shall remain stayed till the next date of listing. So 1911 was the next date. In the meantime, paragraph 11 I am reading. In the meantime, the respondent authority is hereby directed to file their affidavit in opposition, bringing on record all the relevant documents before this court. So that affidavit is yet to come by.
Is the permit?
Yes, next date is 19, main case is 19, 19. May I pray that this IA also this be listed on 19, the notice be issued in the IA,
IA for increment of the representative of the farmer. The farmer, oil farmer, farm oil. We are filing this application for implement in the case, because whatever outcome we will be ultimate will be affected, will be affected. But our crops, it's all the fruit is in rotten condition because of this impugn order, So therefore, our presence in the case is necessary, We are the ultimate affected person.
This, my lord, case is listed today because of this IA, my lord.
Because of?
Because of this IA, my lord, filing of IA, this is listed. Otherwise, my lord, the next date of main case is on 19, my lord, 19, my lord.
It has been listed because of the IA that has been filed my lord, for implement.
May I pray that, my lord, this be.
Otherwise, we may be impleted, my lord.
Impleted, my lord, I have to take instruction, my lord. From the.
Ultimately, my lord, we are the affected person, my lord. Although there is a, whatever the order there, but ultimate affected persons.
My lord, this subject matter relates to palm cultivation and development for benefit of the, my lord, farmers. Now the farmers have filed an application IA for implement. As a petitioner, we don't have any objection, my lord.
No objection.
I don't have any objection. More the merrier, my lord.
Dear my lord, I find, my lord, this IA, my lord, they are praying for implement as a respondent, my lord. Now they are interested in our against, my lord. They are objecting. That's why, my lord, I pray, my lord, this be listed. Next, my lord, I will take instruction, my lord. Next date of the case is fixed. 19, my lord.
19.
19, my lord.
Yes, Mr. Tago?
My lord, all right, otherwise, my lord, 19 also ultimately have to be, my lord, hard, we have to implement, my lord. This is just formality, my lord, notice required to be, otherwise, we have served already notice, my lord, while finding that.
Mr. Parme, we dispose of this,
IA, my lord, at least, my lord, this is past day, my lord, I need some instruction, my lord. Yes, my lord, why? Because, my lord, their interest, my lord, though their prayer is to implement as a respondent, my lord, their interest seems to be in our against, my lord. Therefore, my lord, at least, my lord, I need to inform the authority, concerned authority, my lord, situation, my lord.
We being the farmer, my lord, this is all for our interest, my lord. We have to say on this point, my lord. That's why, my lord.
That we and
outcome it will affecting our right. That's why.
Only for next date, my lord, I will seek instruction, my lord. What is their stand, my lord? Whether they have any objection, my
No,
lord.
there is no next date given. Next date has been given today, my lord, 9th of December. 9th of December is fixed, my lord. This is 9th of December. 1911, that was 1911, you know? You're confused.
Yes, today it has been.
Yes, my lord.
fixed.
So
Then, my lord,
Yes, I may be disposed of, my lord. In the meantime, we'll also file our.
my lord, this is listing today for past time, my lord. I am praying, my lord, next date, by next date, I will say instruction, my lord. So,
Friday.
Next date, my lord, let it be on 19, my lord, 1912, my lord.
19 is not a date fixed, my lord. Today is
Yes,
the
my lord,
date
I
fixed.
understand, I consider, my lord, did not be, my lord. I am praying for, my lord. If
Okay, one by one. First, let us first order in this WPC. You have filed affidavit in opposition.
no, not yet, my lord. We in under process, my lord. I will file shortly, my lord.
Heard Mr. N.K. Chaudhary, learned senior counsel assisted by Mr. M. Sharma, learned counsel for the.
Mr. P. Bharadwaj. P. Bharadwaj.
P. Bharadwaj. And Mr. L. Parnell, learned standing counsel for the Agriculture Department, and Mr. Tagum. You were not in this.
Not yet completed.
But we have
Mr.
filed an additional affidavit today, my lord.
The petition, Mr. Sharma, learned counsel for the petitioner, submits that the petitioner has filed an additional affidavit for this court project.
Bringing on records, my lord, subsequent developments, subsequent to the filing of the petition.
Okay, bringing on record subsequent developments after filing of the petition. Mr. L. Parme, learned counsel for the respondent, submits that he may be granted. No, the matter may be listed on 19th of December.
Too short. It will be too short for you. Take it in January 1st week.
No, my lord, as interim order is operating, my lord. This is issue of public interest, my lord.
Yes, but you have not filed of the.
I'll file, my lord. Shortly, I'll filing, my lord. 19, my lord.
Also, as to enable him to file affidavit in opposition, where is allowed. SSL is the matter on 19th December.
The interim order has to be accepted.
Interim order passed earlier, self-containing.
Highly obliged.
And in IA, you take down, heard Mr. Thakur, learned counsel for the applicant. And Mr. Parme, learned counsel for the respondent number.
My lord, in IA, my lord, for opposite party, 3, 4, and 5, my lord. 3, 4, and 5.
Then Mr. M.K. Sodore, learned senior counsel, assisted by Mr. So-and-so for the respondent number, no, for the opposite party number.
1 and 2.
1 and 2. This interlocutory application is prepared by the applicants for implementing them as party in the WPC number, as respondent in the WPC number 517 of 2024. Mr. L. Parme, learned counsel for the respondent number so-and-so submits that he may be granted time to obtain necessary instruction in this regard, where is accordingly allowed, recessal is the matter of 19 December.
1 copy of one extra copy, my lord, I will require, my lord. 1 extra copy, my lord. Extra copy I will require. my lord.
Mr. Parme submits that the applicant may be directed to furnish a copy of the petition to him. Mr. Tagum, learned counsel for the applicant, submits that he will furnish a copy of the application during the course of the day. Mr. Parme.
My lord, your lordship, may I pray that my submission that I don't have any objection in the implement, that may be recorded, my lord, because we are not filing any objection.
Mr. M.K. Sodore, learned senior counsel for the respondent number 1 and 2, submits that he has no objection in the event of allowing this application.
I think yes.
Okay. Item 6. May I plead, my lord?
Yes.
My lord, this is arising out of the already settled matters. In the year 1996, the petitioner, including other clans, they have donated their ancestral land to the government for establishment of the circle headquarters at Chamba. So that is annexure 1, page number 40, my lord. It will be visible at page number 43, the typed copy here. My lord, here after we have already donated the land to the government free of cost for the interest of the public, my lord. Then we have already entered a preliminary agreement in between the landowners and circle officer who is representing on behalf of the government, the circle officer of Champan. So we have already entered into agreement. Now this land become the government land. Now, after this agreement, my lord, after this agreement, in 1996, we have entered into the agreement. Now, there are 9 clans. 9 clans. In total, 9 clans, we have donated our land to the government. Now, out of these 9 clans, that is phase number 1, phase number 40, that is the name of the clans are there. There are 2 major clans. They have constituted a local committee. Local committee. One committee is called BLCC, Bingdung Land Control Committee, which consists of BEM, Dindo, Buffet, Missing, Lobby. These 5 clans, they formed a committee which is called as Bindung Land Control Committee. And another one is DLCC, means Duri Land Control Committee, that is consisting of Fuji, Taba, Jamru, Jamla, voluntarily donated our land to the state government. Now, in the name of these 2 organizations, this local committee, we have donated our land in 1996. And thereafter, Your Honor, my lord, what happened? Kindly come to page number 47, my lord.
the circle officer of the Chambang, page number 47, madam. Yeah, for a circular issued by the circle officer Chambang. A meeting was fixed on 16 March 2023 from 10:30 a.m. onwards in GB Hall to discuss the land boundary issue regarding the circle headquarters. So, in order to regularize that land by means of getting allotment in the name of for the establishment of the circle officer, madam. This meeting was convinced by the circle officer. And again thereafter, my lord, this meeting, the matter was not been materialized in this boundary issue, circular issued by the circle officer on 9th May 2023. This was not materialized. Then again another circular was a minute of meeting was issued by the circle officer out of this circular dated 9 May 2023. In this circular, my lord, here also this the circle officer has issued the outcome of that 9th May 2023. 3 points was finalized on that meeting. On that meeting, the village circle level land committee, demarcation committee will be formed under the chairmanship of Shri Reba Gade Chambang and vice chairmanship of Shri Gora Tugung ex-ZPM Chambang. This committee will be comprised of members taken from all the concerned segments pertaining to land issue of Chambang Circle Headquarters. So, my lord, this is the outcome of that 9th May 2023. And thereafter, my lord, another circular notice was issued by the circle officer, same circle officer Chambang. Here, the 45 days have been given to the landowners. Any claim and objection over the land ownership, where the land is going to be taken over by the government. So, in any objection, claim or objection over the ownership by the landowners. So, this notice was notice of hearing was issued by the circle officer to the landowners, madam. That is 9 plants. That is totally 9 plants. So, basing on this, my lord, basing on this other plan, that is Duri Land Control Committee, they have submitted no objection. Some of the clan members, they have submitted no objection. I have annexed in the letter. And thereafter, my lord, another minute of meeting public hearing was issued by the circle officer. That is page number 50, my lord. Kindly come to the page number 50, my lord. Here, my lord, in this minute of meeting public hearing issued by the circle officer. Now, kindly come to para 2 of this minute, my lord. May I read, my lord? At the outset, Shri Gora Tugung Vice Chairman welcomed the House and briefed the aim and objections of the sitting. Various speakers from the respective clans flashed their claims and objections before the House, which was followed by an open discussion for way forward. After long deliberation, the House opined that there exist cases of land ownership dispute between Jamru clan versus Puji, Taba, and Jamlo clans, and Miri clan versus Miching clan, consisting the land donation agreement made in the 1996, which needs to be addressed foremostly. So here in this minute of meeting, my lord, Jamru clan is one of the land donator. And Jamru had lodged a complaint against the Fuji, Taba and Jamlo. That means Jamru had donated the land, meaning thereby there's a Fuji and the Taba and the Jamlo are not the land donator. And again, my lord, mirroring plan versus missing plan. Kindly come to page number 40 again, my lord. Here list of this landowner. Mirroring is not there. Only missing is there. Mirroring is not there. But here in this minute of meeting, oblique hearing, mirroring is there. Mirroring is there. Mirroring had lodged a complaint against this missing. At the time of the land donation, the mirroring was not there. Mirroring was not part of the land donator. So after this, my lord, since the complaint is pending before the circle officer, as per this, my lord. So kindly come to terms and condition number 1, serial number 1, my lord. The case of land ownership dispute within the village would be adjudicated by the village authorities, Gamvaras, who are the competent authorities according to the under section 5(1) of the Assam Frontier Administration of Justice Regulation 1945, which states village authorities are empowered to settle civil disputes. Case in customary court is for the Assam Frontier such and such and such and such, read with Arunachal Pradesh Civil Court Act. Hence, the formal record from the office of Sir CO Chambang to the head GB of Chambang East and West respectively shall flash immediately to settle the cases. So there are two cases. One, Jamru versus Puji, Taba and Jamlo. And another one is Miring versus Missing. So circle officer has endorsed this matter to the local authority, my lord. So local authority, kindly come to page number 52, my lord.
52.
52, my lord, 50, annexure 6. As per this endorsement, the Gambara, that is office of the head Gambara, Chambang West, had issued a letter only to the Jamru, Puji and Jamlo, but not to the Miring and the Miching. Subject emergency settlement of land ownership dispute on the basis of the minute of meeting hearing dated 7 December 2023, my lord. So on the basis of this, the head GB, the local authority has issued a notice to only Jamru, Puji and Jamlo 3 clans. But Miring and the Missing had not been issued notice by the local authorities. So this notice which was issued by the head Gambara, this local authority, are not served to us, my lord. And we have not been made there in the party. So we have not been issued notice. So on the basis of this notice, my lord, the local authority has passed an order, that is page number 53, my lord. Page number 53.
Yes?
Page 53, 53. Yes, my lord, annexure 7. This is the order passed by the village authority. That is Gambara, head Gambara, Chambang West. And Chambang East and Chambang West, my lord. So here in this order, which was passed on 22 October 2024, my lord, kindly come to the page number 55. That just operation part, my lord. That is second para. Page number 55, second para. May I read, my lord? Therefore, after considering all the facts and for information as for our Nishi local custom, with the customary court of Chambang Circle, which was set up to adjudicate this case, declared that the real owner of land, which was shown as land donated by DLCC Northeast Zone in 19th agreement is Jamru clan. Only Jamru clan. But as for this agreement, 1996, my lord, annexure 1, there are 9 clans who have donated their respective lands to the government. But here the order passed by the head Gambara, that is like village authority, only Jamru is the landowner. Only Jamru clan. As per this order. My lord, since circle officer had endorsed the land dispute to the local authority, village authority to settle the matter, which is pending between Jamru versus Puji, Taba, and Jamla. And another one is Miring versus Missing. Now I am Missing. Before this order report is Missing plant. So as per this order, if only the Jamru is the landowner, then I am entitled to get back my lands as per this report. Whereas as per 1996 preliminary agreement, our names are there, our clans are there. Since we are there, why our names are not there in the order of this Gamra? Our name has been, our clans has been already removed. Only Jamru is the landowner. So this is an illegal order passed by the village authority without giving any opportunity. Since this circle officer has endorsed a matter to the local authority for the interest of the public. So notice has issued only to the Jamru, Jamlaw, and only Puj and the Jamlaw, not to Taba, not to Miri, no, apart from this Jamru, no plan has been issued notice by the village authority, my lord. So this order is passed very illegally without giving any opportunity. And on the basis of this order, my lord, kindly come to page number 57. On the basis of this Gambora declaration, wherein only the Jamru is the actual landowner over that land in question. Now, on the basis of this declaration order, which has been submitted to the circle officer, Chambang, the circle officer Chambang has issued an order that is page number 57 annexure 8, my lord. The circle officer Chambang has requested that DLRS of Fallen is hereby directed to default their official for the geo mapping of the Chambang circle headquarters, which was fixed on 29 November 2024 at 8 a.m. My lord, since the complaint is there over the land ownership, that is to be determined first. Whether land belongs to Mr. A, whether land belongs to Mr. B. Governor has to determine the issues first. But here in the case, my lord, no proceeding has been taken place, no notice has been served to the other party. Since the meeting is a complainant against the bitching here in the petitioner, no proceeding has been taken place, no notice has been issued, no fair hearing has been conducted, my lord. And my lord, kindly come to page number 58.
Yes.
58, my lord. As per the circle of order issued by the circle officer on 22 November 2024, if any claim and objection by the landowners, 45 days was given to the landowners if any claim and objection is to be filed before the circle officer. So on the basis of that, this other clans, that is Puj clan, who is the one of the land donator, has submitted their no objection. Since we have donated the land to the government, now we have no more honor over that land. So we have no any objection. And subsequently, my lord, again, this is a petitioner. Kindly come to page number 60, my lord. The present petitioner, they have submitted a representation before the Deputy Commissioner, Karadari District, is stating that when the land was donated to the government in 1996, Miring clan was not there, as for the record. Now Miring has lodged complaint against the Missing. Now Missing and the Miring is the same at that moment of time in 1996.
But only in the 2019, they have formed a clan which is called a Miring, my lord. So this is not been considered, it is pending before the deputy commission. My lord, similar matter for the same cause of action has been filed by the other clans, that is Push clan, before this honorable court. Before this honorable court. And this honorable court had stated the operation of order passed by the village authority, that is page number annexure 8, 7, my lord. Age will age. Age will age, page annexure 8. This honorable court has stated the operation of these two orders. One issued by the head Gambura Chambang, and another one is issued by the circle officer on 22 November 2024 for geomapping. These two orders have been issued by this honorable High Court, my lord. Written over with 4 weeks, my lord. So my humble prayer before this honorable court, my lord, similar order may be passed, and this matter may also list together with this earlier petition, my lord. This is my humble submission, my lord.
Mr. Kamdok?
Till returnable date, the operation of this order may be suspended.
My lord, that writ petition, my lord, order which my friend has annexed in the writ petition, my lord. That writ petition, of course, my lord, it was hard in the motion, my lord. Because, my lord, at that point of time, my lord, we have raised an objection about the maintainability, my lord. Because any order passed by the Gambura village authority, my lord, they have the recourse for appeal as per Ordinance Civil Court Act, my lord. The order passed by the village authority that can be challenged before the deputy district judge, my lord, district court.
So because of because of the availability of alternative remedy, this writ petition is not maintained.
Yes, my
That
lord.
is your
Yes, my lord. In the earlier writ petition, my lord, he has made a submission that, my lord, at that very point of time, when this impugn order was passed, my lord, district judge was not there. That is why the order of the Gambura and the C was stayed by this honorable court, my lord. Otherwise, my lord, if that point of time, my lord, if the district court was functioning, my lord.
Now district judge is available?
Available, my lord.
In Kadadri district?
No, my lord, at 0, my lord.
At 0?
At 0, my lord.
0?
Yes, my lord. It comes under the...
Yes, 0 district judge is available?
Yes, my lord. Now, my lord, our submission would be that, my lord, since he has the alternative remedy, my lord, and there is some disputed question of fact involved in this writ petition also, my lord. This court may not be, my lord, able to adjudicate this issue, my lord. As because, my lord, there is a disputed question of fact, my lord. There is a ownership dispute between the clan, my lord. That all those disputes cannot be, my lord, adjudicated by this honorable court in this writ petition, my lord. My humble prayer would be that, my lord, it is the district court, my lord, which will be, my lord, of course, which is the authority, appellate authority under Ordinance Civil Court Act, my lord. Let the petitioner file appropriate this appeal before the appropriate court, my lord.
Before filing appeal before the district judge or any appropriate forum, first of all, appeal has to be filed before the inter-village. Inter-village, one amendment right there. Amendment right there, my lord. This Arunachal Pradesh Civil Court Act Amendment 2022. Here, before appeal to the appropriate forum, appeals is to be filed before the inter-village territorial customary court or effect customary court. But here in the case, my lord, all the head GB, who is the appellate authority,
Other passed by the GB. Other passed by the GB, that is Gamburas. Above the Gambura, that is head Gambura. Head Gambura. So all this Chambing West as well as Chambing East, two head GBs have fast order. Illegally fast order. So kindly come, this is that is my lord. Bam Tatum head GB. Charo Tanam head GB. Taring Minke head GB. Charo Tagum head GB. Pate Tatum head GB. So, as per this provision, the appellant authority in the inter-village level, they have fast orders. They have fast order, illegally, my lord, without giving any opportunity to the petitioners, my lord. Because company,
No,
they are,
but see, this court is not entitled to adjudicate the disputed question of facts. Sitting in the jurisdiction, exercising the jurisdiction. So if a civil court are available there, you go and file a appeal there.
my lord, till then I may be protected, till the filing of my this appeal or something.
No,
Till then,
we are not admitting this matter, and would it be proper to grant such direction?
so my lord, similar matter has been stated by this court and pending before this honorable court.
Another matter is pending.
Yes, my lord, another writ petition is pending, and in that writ petition, my lord, this honorable court has stated this, about this
Yes.
review order, my lord.
Yes.
So therefore, my lord, he's already, my lord, enjoying this interim order, my lord. Because since both these interim order has been stated, my lord. The government administration
the
cannot go
order
ahead with
selects-
this order, my lord.
No, the order challenge in this writ petition is already stated in the other writ.
Yes.
Yes, in
Yes.
the earlier petition.
Then you are already protected.
Yes.
My
You
prayer,
go and avail the
it is
remedy.
protected by some, protected for other clan. That is Fuj clan. Fuj clan.
No, if the entire order is stayed, then
Yes, my lord, that is protected one. In general, it is protected, but in particular, only Fuj clan has filed their petition before this court, which is pending. And now this is a missing clan, who is again opposite party.
no,
So-
if necessary, he can file one implement petition in that writ petition.
So my lord, so matter may be list together, this earlier petition which is
This
pending
matter.
together. So
Okay, then.
Yes, ma'am.
Heard Mr. Entaze, learned counsel for the petitioner, and Mr. Kamluk, learned counsel for the respondent number
1 and 2, my lord.
1 and 2, and madam.
Three. No, 3. Yeah.
Three.
Yes.
Three. In this petition under Article 226 of the Constitution of India, the petitioners are put to challenge correctness or otherwise of the declaration order white number KD stroke CBZ stroke CE -1 2024 dated 22nd October 2024 passed by the head Gaubura Sambang East and the order white number KD CBZ stroke LM -07 of 2022 dated 22nd November 2024 issued by the subdivisional officer Sambang dated 22/11/2024 of Kadagri district, Arunachal Pradesh, and also the declaration order by number KD CBZ stroke CE 1 -1 2024 dated 2022 10/2024 passed by the head governor Sambong Circle, Kadati district, Arunachal Pradesh. Mr. N. Taze learned counsel for the petitioner submits that in connection with the same subject matter, another rate petition is pending before this court being WBC number 562 of 2024. And by order dated 28/11/2024, the impugned orders have already been stayed. That notice has been issued to the parties. Then the matter is listed. Impugned orders stayed. The notice has been issued to the parties, and as such, this matter may be listed along with the aforesaid rate petition, being WBC number 562 of 2024. Accordingly, it is provided that the registrar lists this matter along with WBC number 766. When the next date is fixed in that rate petition, my lord? Whether any date has been fixed? in
No,
the-
no
the
date
rate
has been fixed,
petition?
madam. No date has been fixed.
No.
Yes, only list after 4 weeks.
Registrar lists this rate petition along with the rate petition number.
Obliged, madam. May I please, your lordship? Your lordship, in this case, your lordship, affidavit of the respondent authority is required, your lordship. However, your lordship, as per note, order dated 5 of this month, I was supposed to do the matter today, your lordship. However,
What?
supposed to do this matter today, your lordship. But after going through this petition, your lordship, it is
Mr. Tagam, you have
necessary.
not filed your affidavit in office.
My lord, 2 weeks time may be granted, my lord, although it's based on a record, my lord, even affidavit may not be required, but as a abundant caution, my lord, we may file, my lord.
And madam,
We need some more time, my lordship. We will wait.
you will file your affidavit.
We'll file.
Heard, Mr.
Email, your lordship.
Learned counsel for the petition. Also heard Mr. Tagam, learned counsel for the respondent number
124, my lord.
124, and madam for respondent number
5.
5. Mr. Tagam and madam so press for granting 2 weeks time,
My lord.
so as to enable them to file affidavit in opposition. Here is accordingly allowed. In the event of failing to file affidavit in opposition on next date, the court will proceed to hear and dispose of the matter
As per record.
on the basis of
Right.
materials placed on record.
Ma'am.
May I please, your lordship? Your lordship, item number 8 is same as 7, your lordship.
8.
Yes, your lordship.
Okay.
Same order. Much obliged.
My lord, my sincere apology for inconvenience and also, my lord, not filing the status report on affidavit. My lord, as per order dated 2110, we are supposed to file the status report in the form of affidavit. Now, my lord, we have received the instruction from the department, the latest status. Now, my lord, as per the rules, this matter has been referred to the Public Service Commission for their comments, my lord. Since he's a class 1 officer, so, my lord, the things has been rotated to the Public Service Commission, my lord. And the query has been made by the Secretary to the Governor. The lordship said the paragraph 9, 9 and 10, my lord. The query was made from His Excellency, the whether the Public Service Commission, my lord, their consultancy is required or not, my lord.
My submission.
My lord, now as per this Public Service Commission Limitation Function Regulation 1988 as amended, since he's a class 1 officer, my lord, their consent is required, my lord. So that's why he should be referred to the Public Service Commission for final comments, my lord. So we are awaited for that, my lord, from the Public Service Commission, my lord. Once, my lord, we receive, then we can refer it back to His Excellency for final disposal of the appeal, my lord.
Okay, when can it be listed?
So can it be listed after, my lord, 2 weeks or 3 weeks, my lord? I believe, my lord, till then, if your lordship see the date, my lord, it was reported on 22nd November only, my lord.
My case is different. My point is that 35/2023, there was a departmental inquiry. On the basis of departmental inquiry, on 9/11/2023, I was dismissed from the service. Now, as per CCS, Rule 23, there is a provision to make an appeal. On the basis of the provisions, I made the appeal on 30/9/2023. Now, that has not been disposed of. That's why I have filed the WPC. Because unless I make an appeal, I cannot come to the here in the court. Now I have made an appeal, and whether that appeal will be live independently in before the appellate authority, on that way, whether my right will be curtailed. Because 1 year has already been passed, but the appeal was not disposed. Your lordship will say that's why you have not appealed. I have made an appeal. Since it is not disposed of, it becomes pending. I am compelled to come to the court to hear my WPC.
My lord, we are not disputing the facts, my lord. We are not disputing the
And
facts,
then
my
it
lord.
of the inquiry proceeding. Prior to this, we were going to the single bench judge, then double bench. In the single bench also, press directed to make a press inquiry. Even in the DB also, the order was press inquiry, but they have not done any press inquiry. And on the basis of the earlier deposition, they have taken the order. They have passed the order. They take on 9/9/2020.
My lord, I have to interrupt here, my lord. My lord, that is not the correct submission, my lord. That is not the correct fact, my lord. Even the inquiry officer presentation, my lord, again, re-examination, all the witnesses were done. But it's all videographed, my lord. It's all recorded, my lord.
And I have
that way my Lord
and
Senior
the
Counsel
authority.
submission is not correct, my lord. That's wrong. Sir.
When departmental inquiry was done, a witness should come to depose and state the fact, whatever he knows as per his knowledge. But here in the case is there, inquiry officer put enter leading question before he speaks. The statement was made by the witnesses. The entirety of the question was put in the leading question. And simply, the witnesses simply said yes or no, yes or no, yes or no. And there was no preliminary inquiry. After when the court said the press inquiry, in that case, while doing before the starting of the preliminary inquiry, there should be a preliminary inquiry. There is no such preliminary inquiry here in the case. So this is a clear-cut bias.
Okay, let's file affidavit then.
My lord, now
It says
present writ petition is filed. for no disposal of the appeal, my lord. He is not challenging the, my lord, Department of Procedures, my lord. Here the prayer is, my lord, early disposal of the appeal.
Appeal.
Yes. Now, why he is arguing, my lord, the procedure left side, my lord? Every departmental, my lord, procedure is the safeguard for the any government influence, my lord. Yes. Now, my lord, he should keep it safe, my lord, that procedure if there is any lapses, my lord. But here is the case, my lord, no disposal of the appeal, my lord. As I have apprised, my lord, the matter has been placed before the Public Service Commission, my lord. Once we get the comments from the Public Service Commission, then it will be referred back to the Secretary His Excellency.
Before the
Yes, my
governor.
lord. Yes, my lord.
So,
So at least 3 weeks might be granted, my lord. We are trying our best, my lord. Now it's up to Public Service Commission, my lord.
Granting of 3 weeks is too much.
No, heaven will not fall, my lord. If you can wait for so many years, then why not another 3 weeks, my lord? We are trying our best, my lord. Now we cannot insist Public Service Commission to give tomorrow itself, my lord. We can do that also. They are independent, autonomous body, my lord. We cannot dictate them. My lord. That is the problem, my lord.
so we'll fix it that after 2 weeks. In the meantime, let him file application.
My lord, file, my lord, this status report or my lord, your lordship is asking us to file the affidavit, my lord. My lord, what sort of affidavit or this status or my lord after 2
What
weeks?
is status?
This is status.
No, regarding the status of that
Public
report
Service
from
Commission.
Public Service Commission.
My lord, very good. Then your lordship may kindly allow the government advocate to file the status report, my lord.
Government advocate.
Yes, my lord. If there is no specific order, my lord, last time one of my judge or my lord, he was heckled by this, my lord, my lord. There is no such order authorizing the government advocate to file an affidavit, my lord. The situation we have faced, my lord.
So you are representing
My lord, I'm representing respondent number 1, 2, and 4, my lord.
1, 2, and 4. And
1,
Madam
3, and
Pango,
4. 1, 3, and 4.
you are?
No, my lord, she's assisting me.
Acha, acha. So you have to file affidavit.
Yes.
You have to file status report.
Yes.
Third, Mr. M. Party, learned senior counsel assisted by Mr. Learned counsel for the petitioner and Mr. R.S. Nava, learned additional advocate general for the respondent members. Mr. Nava, learned additional advocate general. A report. To produce a letter written by
Is it Commissioner Tax and
Commissioner,
Excise, my lord.
Tax, Excise and Narcotics.
Yes.
Itanagar. To the Secretary, Arunachal Pradesh Public Service Commission, requesting for comment of the APPSC with respect to imposition of penalty of dismissal from service upon Sri Tommy Chomke, ex-Joint Commissioner, within bracket Tax, Excise and Narcotics regard. And Mr. Nagam pressed for granting him 2 weeks time to submit one status report about the letter authored by written by the Commissioner, Tax, Excise and Narcotics, Itanagar, to the Secretary of Arunachal Pradesh Public Service Commission, Itanagar. Where is accordingly allowed to list the matter on before vacation?
20?
23. 23?
23, 12, my lord. Well, deeply appreciated.
May I please, Your Lordship, this IA has been filed to modify the order in WPC number 537. Your Lordship, this we are impugning the transfer and posting order passed by the respondent authority. Your Lordship, this has been passed purely on malafide intention under the political consideration. Your Lordship. Moreover, Your Lordship, this is where annexure number annexure A, Your Lordship,
What
page
is that
number.
order? 1911-24?
Yes, Your Lordship.
1911-24, what
19
is that order?
Order
Page
is Your Lordship in 19/9/24.
That page number?
Page number 16, Your Lordship. This is Your Lordship impugn order, transfer order. This is 16. And 11/9/11 is page number 20 years. And 21 is the, may I read yours? Had Mr. M. Halley, Learned Counsel for the petitioner, the present petition has been filed impugning the order dated 19/9/24, transferring the petitioner from BRC Daporizo Upper Suwans District to Secondary School, Laju, Tirap. Issue notice to the respondent returnable 4 weeks old. The Tagum Learned Standing Council Education Department appears for the respondent number 1 to 5. Therefore, no formal notice need to be issued to the said respondent. The Learned Counsel for the petitioner shall, however, serve requisite extra copies of the read petition to the Learned Standing Council for the Education Department within 2 weeks. Insofar as the respondent 6 is concerned, Learned Counsel for the petitioner shall take steps for service of notice upon respondent by registered AD post. That much only, Your Lordship. My prayer for the interim has not been granted. Nothing has been reflected, Your Lordship. This impugn order, transfer order has been made completely on political consideration, Your Lordship. That in my annexure, Your Lordship, one UD, unofficial note recommending the transfer of the transfer of my transfer made by the local MLA of 26
Maybe there is one judgment of the Supreme Court there that there is nothing wrong with the recommendation of the MLA or MP in transferring of a particular officer or staff.
Your Lordship, the MLA MLA who made the recommendation is from 22nd Nacho Assembly Constituency, but I am serving as in 24 Daporizo. So Lordship, this he has no any jurisdiction to make such not Your Lordship. Exact, Your Lordship, it is prima facie, it is established that the note which has been made, serial number as it is copy paste is made in the impugn order, impugn transfer order. The prima facie it is there. Malafide intention.
They were transferred from which place to which place?
From Daporizo to, Your Lordship, Laju, that is Tirap, Teju, Tirap district. Your Lordship, moreover, I am now at the birth of my superannuation. I am now 55 plus years, and I am I am also suffering from disease and taking medication at 3 years. I have submitted one, Your Lordship, in my annexure number F, page number 37. I have made an application before the DDSC Daporizo also for my inability to move from one place to another place, strictly, Your Lordship. In support of this representation, I have annexed the certificate of treatment from the concerned doctor from TRIMS, Your Lordship. I am suffering from, Your Lordship, multi-level carbonyl and the lumbar. That is my spinal cord. Strictly, I am advised to take rest, not to go any journey especially. So I am even now unable to received the release order from the,
Where it is advised to take rest.
Your Honor, in para 2, review at PMR OPD trims in every 2 weeks, 2 months. And
Paragraph of page number.
page number 38, Your Honor. 27, with effect from 27/4 to 23 to till that, Your Lordship. And I have been advised to come after every 2 months. Now I am in my bed rest, Your Lordship. And continuously the physiotherapy is going on it. Due to old age,
Yes,
Your Lordship.
Mr. Tagong.
My lord has already, my lord, rightly pointed out that every transfer posting, my lord, initiated at the behest of political, my lord, MLA, MP, may not be vitiated, my lord. That is settled, my lord. Only, my lord, what is required to be looked into is whether there is a mala fight behind the issuance of such recommendation, or that's only to be, my lord. And whether authority has exercised independently, my lord, on the basis of that recommendation, whether they have applied the mind or not. My lord, in that case, my lord, the mala fight, my lord, the part, my lord, that has to be established, my lord. Otherwise, only mere recommendation, my lord, that may not be a ground, my lord. And political, my lord, so far health issue is concerned, my lord, since he has already filed the representation, my lord, this can be considered, my lord.
Representation.
Yes, representation is already filed.
Before?
Before the Deputy Director School Education.
Deputy?
Director School Education, page 37. Citing his medical ground.
So this representation is yet to be disclosed.
Well, it can be disposed of.
Your Lordship, malified intention can be drawn from, Your Lordship, the exact, whatever note has been made by the MLA, exactly it has been printed in the impugn order. Exactly serial number, everything, name, in from starting from page number, serial number 32, serial number 62 to 67. Exact copy paste from the note which has been made by the MLA. So from this, your malified intention can be drawn, Your Lordship.
So, okay, Mr. Tagong.
Yes, madam.
You obtain instruction as to whether this representation is disposed of or not.
Madam.
When you have filed this representation?
On 18/11.
But below the.
It received on
second of
second
December.
12.
Second
Second
December.
12.
Recently, madam.
The moment I have been admitted at TRIMS hospital, I have submitted the representation, but it has been received lately on 2/12.
You obtain verbal instruction.
Madam.
We'll take it up day after tomorrow then.
Madam.
Heard Mr. Your good name?
Kegara.
Then also heard Mr. T. Dagam, Learned Counsel for the opposite party. This interlocutory application is preferred by the applicant for modification of the order dated 19/11/2024, hosting WPC number 537 of 2024. The learned counsel for the applicant submits that he had preferred one WPC, being WPC number 537 of 2024, challenging his transfer order dated 19/9/2024, memo number ED 12012, between bracket 11/8/ dated 11/10/2024, made on the recommendation of the MLA. And in the said writ petition, no interim order was passed by this court. And that the applicant is suffering from serious ailment and he has been admitted at TRIMS. And he has also filed one representation before the Deputy Director of School Education, the Upper Subansiri District, for reconsideration of his transfer. And the said representation is yet to be disposed of. But in view of the submission of the learned counsel for the applicant, it is provided that Mr. Tagum, learned counsel for the respondent authorities, shall obtain necessary instruction as to the status of the representation dated 18/11/2024, filed by the petitioner before the Deputy Director of School Education, Daporizo. List the matter on day after tomorrow.
Obliged.
Item number 13 and 14.
May I please, Your Lordship?
Yes.
I am appearing in response item number 13. This is an RA in contempt petition, that is item number 14.
Yes.
IA has been filed by the LS contempt number 1, that is Rajiv Gowa, Cabinet Secretary, to delete his name from the contempt petition on the basis of kindly come to my lord, page number 7, my lord.
Yes.
Page number 7, in paragraph number 2, we have stated that the applicant begs to submit that the respondent number 1, the Cabinet Secretary to the Government of India, is not necessary party in as much as the President of India has formulated 2 sets of rule under Article 77(3) of the Constitution of India for convenient transaction of the business of the Union under the Government of India, the rule in 1961. Business of the Government of India is allocated by assigning one or more department in the charge of the minister under the Government of India, Rule 1961. The business of the department is disposed of by or under the general or special direction of the minister in charge. In short, the business allocated to the Ministry of Defense is disposed of by the minister in charge after following the rule cited above. Therefore, as per guideline, that is the guideline, my lord, on the basis of which we have filed this petition. Therefore, as per the guideline contained in the office memorandum height number so-and-so dated 8/5/2015 of the Government of India, Ministry of Law and Justice, Department of Legal Affairs, Judicial Section, the name of the Cabinet Secretary to whom the subject matter of the instant petition is not allocated. As such, the name of the applicant number 1 may be deleted from the aforesaid contempt case. And that annexure A, that is page number
My lord,
11.
I'm not objecting to this I application.
Yeah, no objection.
No objection.
That may be disposed of, my lord. On the basis of that is in annexure, my lord, we have already annexed that notification 8/5. That is annexure A. Page number, my lord, page number.
Oh, okay, madam, the petitioner submits that he has no objection in the
And
event
my
of
lord,
allowing
dispose.
this.
Yes, my lord. Yes, my lord.
Yeah.
Part Ms. Gayon, learned.
Yeah, please, Lordship. Lordship, I'm for the respondent number 9, Lordship. I may be allowed some more time to file my affidavit in opposition, Lordship.
In I,
No, not I.
in main petition.
Main petition, Lordship.
Learned counsel for the applicant and Mr.
Odugong.
Learned counsel for the respondent. Respondent number? You have for respondent number?
No, I am petitioner.
No, in this IA.
Oh, I am the sole respondent number 1. Sole respondent, there is only
In page number 5.
Dondup Johnson, respondent number 1.
Page number 5, respondent number 1.
Respondent number one.
Yes.
Okay. For the sole respondent, opposite party number one. This interlocutory application is preferred for striking out the name of respondent number one. That is Sri Rajiv Gauba, the cabinet secretary to the Government of India from the era of the petition. In content case number 27, we can look at 80/2023. Ms. Gayo, learned counsel for the applicant submits that the applicant is not a necessary party in the contempt petition, and as such, his name may be deleted from the array of the contempt petition number so and so so. The learned counsel for the sole respondent stroke opposite party submits that he has no objection in the event of deleting the name of the applicant from the array of the contempt petition. In view of the submission of learned counsel for both the parties and also taking note of the facts and circumstances on the record, this court is inclined to allow this application. The name of the applicant be deleted from the array of the contempt petition number so and so so and so. In terms of this file is closed.
In contempt petition, I'm appearing on behalf of 3, 4, and 5.
But Mr. So learned counsel for the petitioner and Madam Gayon for respondent number 3 to 5 and
Yes.
you
I am for the 9, Lord.
respondent number 9. You take down in the other order. Necessary correction may be made in the contempt petition in view of order passed in I number so and so. So you have not filed your affidavit in opposition.
Yes, Lordship.
We require some time to, yes, in also, we also require some time to file affidavit in 3, 4, 5.
Ms. Gayon, learned counsel for the respondent number 3 to 5, Mr. Yogutem, please.
Ed Noble.
Learned counsel for the respondent number 9.
Yes, Lordship.
Press for granting 2 weeks time.
Minus 4 weeks. 4 weeks.
Lordship, 4 weeks maybe
4 weeks
granted.
time to file affidavit in opposition. Where is accordingly allowed, this is always the matter after 4 weeks.
Yes.
Deeply
Must-
obliged.
must-
May I please, Your Lordship, I am sorry to interfere, Lordship. In item number 10, I am appearing for respondent number 2. Item number 10, Lordship.
Yes.
It was not called, 13 and 14 has been called.
No, item number 10, someone has mentioned the matter
Lordship.
already.
Yes, madam.
Item number 10, Lordship, let the date may be fixed because I am from outside, Lordship.
Yes, that is 18, my lord, I believe. 18.
16.
Yes. 18. 18.
Yes, fix on 18/12.
Lordship.
Okay.
May I sign, my lord? Here, my lord, I am for private respondent, my lord. Morning, I have filed my authority and my lord, opinion opposition, my lord. Necessarily, I have filed morning, in the morning, my lord.
Today morning.
Today morning, my authority.
Well, there is a sensitiveness in this matter because in violation of the OMs and all the statutory rules, somebody has changed his date of birth after lapse of many years. The rule provides that it should be
Within 3
within the
years.
period of 5 years.
5 years or 3 years?
5 years. And then that's why, although he has not served it, but if my lord, I want to argue this matter on merit. And making it very clear, I will not peruse his affidavit also. because the government affidavit, he cannot take a contrary view. All the records has been brought in by the government affidavit. Government says 95, they have already rejected once. Then 2015, then when it came there, then only this thing is happened.
Then my lord may record that he is not Perus. My affidavit, my lord may fix the matter on 12th, my lord. Ultimately, my lord need to file my affidavit, Perus my record, my lord. If he don't want to Perus, my lord, let my lord record. He don't want to Perus my affidavit in opposition, my lord, and on 12th, my lord, case can be disposed of, my lord.
It is not a case if you have not filed today, because see, sometimes what will happen is my youngers or some of my friends, they tends to forget the rules book. The rule provides within so and so days they have to file. But I have seen many of my friends, whenever they have this case, they will place the rules. But I am a one who accommodates them. But my magnanimity sometimes has always been taken it very lightly by my friends and my youngers. But now time has come where I have to take a step. In any case, if he has filed today, he has not served me the copy. In bonus, I am giving you 1 week time. Okay. In bonus, I am giving him 1 week time. But prophesy, there is no merit in his case.
Maybe,
but overstay. In any case,
We are bound to hurt him. We are bound to peruse his affidavit.
And
that may not be taken into account while deciding the merit of the case. But opportunity has to be afforded. Otherwise, tomorrow he will go to Supreme Court and he will submit that I have not been given an opportunity of being heard.
This is
My
my-
affidavit has not been perused by the court.
This is my second
No,
appearance in
no,
this case, my lord. Second
I'm not
appearance.
saying that because my brother says that he is filing his affidavit today. And on the other hand, he says that my lord may report my statement.
Well, he says
I will not peruse.
he don't
his
want to
affidavit.
peruse, my lord.
Now you file today. I will give you a bonus of 7 days. Well, can we have
So he suggested that. We
this
will
case
decide
has to
it.
be finished in any case, my lord. My lord will have it on 15, Monday. 15. Monday will be more appropriate. Or Tuesday.
Tuesday I have one. 15 it's okay, my lord.
15
Oh, sorry, my lord. 15 is Sunday, my lord.
Huh?
15 is Sunday, my lord.
Sorry.
Yes.
December ka? No, 15. Oh, sorry. No, somebody has given me which dates will be taken.
18, sir.
Okay.
18.
17.
17.
17.
Okay. Heard Mr. T.D. Tara, learned counsel for the petitioner, and Mr. L. Parme, learned counsel for the respondent number 4.
4, my lord. Respondent
And
4, my lord.
Madam Wangmo for respondent number 1, 2, and 3. Mr. Parme submits that he has filed the affidavit in opposition today morning. Mr. Tara, learned counsel for the petitioner, submits that he has not been served with a copy of the affidavit. Accordingly, it is provided that Mr. Parme shall furnish a copy of the affidavit in opposition to Mr. Tara during the course of the day. Rest is a list the matter on next Monday.
Sorry, my 17, my lord. Monday I have problem.
17.
16 I have problem.
Oh, this
17.
Oh, highly on it.
Item number 16.
Maladi, here I am appearing on behalf of Respondent Union of India, my lord.
Respondent?
Union of India, my lord.
Union.
So, my lord, we wanted to file my lord, the affidavit, my lord. So, therefore, my lord, 4 weeks time may be granted, my lord.
Maybe 20 January maybe fix. Senior is out of station, so he will available on 20 January, 20 of January, 2020.
On
20 January.
20 January.
Yes.
Okay.
My lord.
And
Pardon, sir, your-
interim is there. Interim may be continued.
Okay. Your good name, please.
T Noma.
Learned counsel for the petitioner, and Mr. Kato, learned standing counsel for the respondent number
For all respondents, ma'am. All respondents, ma'am.
For the respondents. For the respondents. Mr. Kato submits that he has not yet filed the affidavit in opposition and he may be granted for instance.
Madam.
Here is accordingly allowed. Dismissal is the matter after 4 weeks. Till then, interim order pass earlier self-contained.
Well, development.
Item number 18.
Lordship, I have a small prayer here, Your Lordship. Senior government advocate Estapin would appear in this case, Your Lordship. He's not well today, Your Lordship. So if
Madam,
it can be taken up on 11, Your Lordship.
my respectful submission, my lord. Let his part be kept, my lord, for day after tomorrow, my lord. As asking for day after, my lord, I'll do my part, my lord, because so many respondents there, my lord. Now, rather, I'll be relying the affidavit of the government, my lord. Even they do not present, my lord, I'll be relying their affidavit only, my lord. Even for their presence, if required, my lord, they can be heard. Whatever the submission they make, they can be made day after tomorrow, my lord. If they are asking for day after tomorrow, my lord, my part may be allowed to be, my lord. And other respondent also there, my lord. And my lord,
Lordship, here one problem may arise because he is questioning the OM, Office Memorandum of 2007. So to us, this is our recruitment rule. I'm for Arunachal Pradesh Public Service Commission. Now, if recruitment rule is challenged, so this is a policy of the government. If policy of the government is challenged, then Advocate General may require to address the Honorable Court.
my respectful submission, it is not at all, I'm not touching the recruitment rule at all, my lord. My lord, this is whatever they are relying on the administrative, that is administrative instruction, my lord. OM is nothing but administrative instruction, my lord. Now, whether it will supersede the statutory rules or not, my lord. To that effect, the specific on a special direction of this Honorable Court, the administrative reform who has issued the office memorandum, they have filed the affidavit clarifying that state. Now, where is the question of the raising this issue, my lord? The main department, administrative reform, they have filed affidavit.
Mr. Kago,
My lord.
tell me whether you have challenged the rule here or not.
My lord, rule is not required to be challenged at all. It is in my favor, my lord. How that is their interpretation. They're trying to say that something, my lord. It is in my favor, and there's no question of challenging recruitment rule, my lord. There's no recruitment rule, the question of challenge. It's my favor, my lord. Only they are relying on OM, my lord. OM also in my favor. Also, how it is in my favor, my lord. And to that effect, even administrative reform department have a specific on the order direction issued by this one. They have filed the affidavit, my lord. I'll be relying on their affidavit, my lord, filed by the government, my lord. This issue was raised, my lord, earlier, and having considered his submission and earlier occasion, my lord, this honorable causes directed administrative reform to be implemented as the administrative reform department was not met as a party. It was implemented and directed to file the affidavit. According to the affidavit, they have filed, my lord, clarifying their state, my lord. The OM has nothing to do. That is always subject to the statutory rules and act. The administrative instruction cannot override the statutory rules. They have clarified, my lord.
Anyway, I'm ready for that.
But that is why, my lord,
because government has sick time.
this is why, my lord, this is my respect. I mean, this is a person with disability, my lord. He's suffering like anything because of the fault committed by the commission, my lord. And that is why, my lord, I personally, my lord, feel it serious, my lord, for this dragging, my lord, this matter. One pretext or the other, the petition parties are dragging the matter, my lord. That's why, my lord. That's why there's a urgency of this disposal of the matter, my lord. That's why, my lord. Otherwise, it's a very simple issue, my lord, in my respectful submission. It's a very simple, there's no confusion. What they're trying to create a confusion, it is, may not acceptable, my lord. Also, my lord, it's very simple, my lord. My lord, simple gist of the case, my lord.
Okay. Yes, madam, let him do his part today.
Yeah. I'll be relying his part. My lord, just before coming to the detail, my lord, I'll just highlight the gist, my lord. Now, 2008, office memorandum has been issued by Department of District Administrative Reform, prescribing as to how the procedure of the interviews to be done, madam. It says that 1:3 against each vacancy, madam, has to be called for interview who is qualified, madam, in the written test, madam. This is, madam, and the person who is to be qualified, who is the qualified person? It is mentioned in the OM that is referred to by my senior counsel, madam. I'll come to that in detail, madam. That says that 1:3 for each vacancy. That is against one vacancy, 3 persons will be called for. The pointed to the bottom line of this point is against each vacancy, madam. And the aggregate minimum passing mark, qualifying mark is 33%. And in aggregate, at least aggregate total 45% should be there for calling person eligible for interview, madam. This is what this OMs talk about 2008. Madam. Basing on this, madam, the Arunachal Pradesh Public Service Commission, they issued advertisement calling for filling up of 60 assistant engineer, wherein, madam, 5 posts were reserved for person with disability categorically. And they are also specifically mentioned 3:4 for each vacancy, madam. Now, I participated, my name was shortlisted in the category of PWD, person with disability. I participated, and from my part, madam, I done it exceedingly well, madam. But unfortunately, when the result was notified on 2019, my name is not was not in the list. Only one PW candidate was only listed, madam. Then I filed the RTI, wherein they have furnished altogether in RTI. They have said that altogether 29% participated in PWD candidate, out of which, my lord, 4%, my lord, 4% has secured 33 and above, and 3% 33 and 45 above, man. My case falls under 45 above, man. They have, on RTI reply, they have furnished my mark sheet, and I secured 48%, 37%, man. Now, and the post reserve for PWD is, my lord, 5, my lord. The only one candidate against PWD has been selected, and remaining, my lord, 4 posts there, and I'm in among the 3 candidates, including who's already selected, my lord, against the 5 posts, my lord. This is, my lord, in this aspect, my lord, detail. When the earlier occasion, when the hearing was taken place, then a query was put forward by argument was put forward by the senior counsel on behalf of the FCS commissioner, saying that we have conducted on the basis of the OM dated 2008. Now, 2008 does not say that whatever they are projecting, my lord. Then in this regard, this Honorable Court has directed the Department of Administrative Reform to be implemented as the respondent 12 and file affidavit there stand with regard to the OM that 2008, my lord. They filed affidavit saying that this OM cannot supersede the statutory rules, my lord. It's always subject to rules and act of the government, my lord. That is what they said, my lord. Now, in the railway annex, even the rule they have annexed, the state have framed their own rule, my lord, invoking the provision under the Person with Disability Act 2016. The state government has framed that rules in my favor, my lord. That is, my lord, the whole case, my lord. They have illegally, my name has been ignored because of default on part of the FCS Commission, my lord, Arunachal Pradesh Public Service Commission, my lord. And this case was, my lord, pending since long because of there was a corruption allegation against the FCS Commission, my lord. It was dissolved, almost non-function for years together, my lord. And recently, my lord, reconstituted after holding series of meeting in the stakeholder, my lord. It was one of the darkest hours of the state of Arunachal Pradesh, my lord. Now the new commission has come up. Now, because of this, this matter has been pending for a long time. Now, my lord, I'll come to the detail, my lord. My lord, you see at page 48, my lord, of my writ petition, my lord. 48. This is page 48, my lord. 48, 49. This is what the OM that is 7 January 2008, man. Selection of candidate for appearing in viva voce test on the basis of recruitment examination procedure thereof, my lord. From second para, my lord. After careful examination of issue and modification, point number 2 and 3 of OM dated so, the governor of Arunachal Pradesh has decided to prescribe the following procedure for all direct recruitment examination for group appointment of group A, B, and C post service under government of Arunachal Pradesh. Number 1, for appearing in viva voce test, candidates shall be selected in the ratio of 1:3, meaning 3 candidates shall be selected for each vacancy. Here, each vacancy is not important. It's to be not. I'll rely later on how that is important. Each vacancy, against each vacancy, 3% for calling interview, 3 times number so on the basis of written examination paper. However, ratio of 3:1, 1:3 shall not apply in case of a candidate appearing in the written examination less than 3 times of the number of the vacancy. In case of the candidate appearing in the written examination is less than 3 times of the number of vacancy, all the candidates securing 33% of marks in the written examination shall be eligible for appearing viva voce test. 2, my lord. Candidates securing minimum 33% or more marks in each written examination paper and has secured 45 marks out of aggregate total marks in the written examination shall be eligible for viva voce test. This is the OM, my lord. Now it says it's to be selected against each vacancy. My lord, we see at the advertisement at page 50, my lord.
Yes.
My lord, initially at page 50, initially post was 38 post, my lord. The second paragraph, my lord, detailed post reserved for PWD candidate as follows, my lord. Although in number 1 also it's clear mention, my lord. PWD, my lord, Arunachal Pradesh Public Work Department, 1 vacancy, low vision and locomotory disability.
You are referring to point number?
My lord, this also, my lord, the point number 1, my lord, is talk about, it is also clearly mentioned. The chart, my lord, down below chart is there. I'll my lord, number 1, my lord, 22 posts, 17 posts reserved for APST candidates, 1 post reserved for Arunachal Pradesh State APST PWD, person with disability, and 4 posts unreserved for open competition. Then PHE, my lord, PHE and water supply, 3 posts, 2 posts reserved for APST and 1 post reserved for APST PWD candidate. Then Arunachal C, my lord, 7 posts, 5 posts reserved for APST candidate, 1 post reserved for PWD candidate, my lord. And RWD, my lord, WRD, 6 posts. Out of 6 posts, 3 posts reserved for APST and 2 posts reserved for APST PWD, person with disability. Now chart is given below, my lord, detail, my lord. PWD 1 post against PWD candidate, my lord. PHE, my lord, 1. RWD 2, 1, my lord. WRD 2, my lord. All together, my lord, 5%. 5 candidate, 5 posts was reserved for PWD candidate, my lord. Now this 5 posts is meant for PWD. It's not for general category, my lord. That is why then each vacant post, my lord, it's 5 posts is for PWD, the person with disability, my lord. Now page 51, my lord. Method of selection, my lord, it's based on written examination. This there. And second paragraph, my lord. Number of candidates who shall call for personality test, viva voice interview will be in the ratio of 1:3, my lord. Candidate so. Subject to securing a minimum 33% or more marks in the written paper and 45 marks of aggregate out of total marks in the written examination. This is the criteria for calling of interview to the person who qualified in the written. To qualified, at least 33%, in aggregate 45%. Now, pursuant to this advertisement, total, you see, this later on this post, total post, it has been enhanced to 60 at page 55. Total post is 60, but reserve post is remain as it is, Page 55, total post 60. Out of reserve, the the Arunachal Pradesh scheduled tribe, 49, Within that, 5 posts is intact, against person with disability, Now, pursuant to this advertisement, petitioner duly filled up and submitted the application, and his name was shortlisted at page 56, Altogether, 29 persons with disability were enlisted, shortlisted for appearing in written examination, The petitioner's name appears at serial number 29, Orthopedically handicapped permanent, Now, accordingly, page 57, admit card was issued to the petitioner, bearing rule number so and so, 57, Now, after this, petitioner has participated as per the scheduled date mentioned in the admit card, He done exceedingly well in examination, but unfortunately, when result was published, written examination result was published on 12 February 2019, at page 58. The name of petitioner was not appears in the selected this qualified written examination. Only out of this 29 PWD candidate who participated, only one, at page 59, serial number 144, Serial number 144. This is the only one PWD candidate. Her name was appeared. And rest, it's not appeared, it has not been appeared in the selection list. Then, accordingly, the final selection was done on 21 June 2019, at page 61, Page 61. No PWD candidate selected. No PWD candidate selected, except that one which is reflected in serial number, just previous page, 144 serial number. And page 53, her name is at serial number 59. Nabum Yakte. Only one candidate was selected, against PWD quota, PHE and water supply. Now, after this, at page 24, the one post was remained vacant, Page 64, Because total post is, 60 posts. Out of that, they have already filled up 59, And one post remained vacant, 64, It has been kept vacant for the next succeeding recruitment, Now, this vacant post, madam, there's a stay, madam, not to fill up, madam. In this case, madam, there's a stay order operating against this, not to fill up this post during the pendency, madam.
Pendency of this petition.
Yes, madam. This has to be kept vacant, madam, not to be filled up, madam. Now, now, my lord, even the state government, Department of Administrative Reform, my lord, they have directed all the department to maintain reservation of PWD as per Act and rules, my lord, at page 65, my lord. Page office memorandum dated 21 June 2012. My lord. Subject reservation of post service in group A, B, C for physically handicapped person under government of Arunachal Pradesh. Modified, my lord. Second paragraph, my lord. Relevant paragraph only. It is therefore impressed upon all the appointing authorities that 3% of posts reserved for physically handicapped person shall be applicable to all the categories of post group A, B, and C, which are identified for disabled categories, White Office Memorandum number so and so. Therefore, my lord, last bottom, my lord, last paragraph. Any other terms and conditions which are not specified herein shall be governed by relevant act, rules, guidelines issued by the government in the matter from time to time, my lord. Now here, my lord, it's clarified. The act will, my lord, whatever the act will prevail, statutory rules will prevail, my lord, in this regard. So for other reservation part is concerned, if it is not specifically mentioned, my lord. Now, this detail after having seen this all anomalies, my lord, I filed RTI. RTI reply, my lord, you see at page 76. My lord, got it, my lord.
Yes.
My lord, serial number 2. Total 5 posts were reserved for PWD candidate. 3, there were total 29 PWD candidates, including applicant to whom the admit card were issued. 5, my lord. Amongst PWD candidate, MS so-and-so bearing rule number so-and-so had qualified in written examination and has also got selection as well. Now, my lord, 12 and 13, 12, my lord. Only 4 candidates secured 33% and above. 13, my 3 candidates secured 45 and above. My case falls under 45. Now, when it say that 3 candidates, one has already been appointed, as it has been mentioned at serial number 5, my lord. Now 2 remains, my lord. My case falls under this, my lord, because I've secured 48%, my lord. My marked statement, my lord, you see at page 78, my lord. Furnished through RTA, my lord. 78, my lord. General knowledge 48, general English 50, civil engineer 95.5, and total 193, my lord. Now, if we calculate percentage, it comes to 48%, 0.37%, my lord. I qualified more than 45 marks, my lord. Secured, my lord. Therefore, from the records, my lord, from RTI, as I was found to be qualified in written examination and I was not called for interview. Then I made a representation on that at 25/10/2019. My lord will see my representation at page 79, my lord. Page 79. Complaint against non-selection of so-and-so in written examination and viva voce so-and-so against orthopedical handicap reserve quota under PWD category, despite same being qualified in written examination in terms of advertisement dated and its addendum dated. Although he is qualified, this representation was submitted, but till then, same has not been considered, my lord. Now, now in this similar, my lord, same, my lord, in the previous occasion, my lord, previous, I have annexed the previous mark statement of previous year also, my lord. My lord, in the previous occasion, previous year, immediately previous year, the previous preceding year of recruitment, my lord, they even person who were below 45% were appointed, my lord. My lord, you see page 108, my lord. Previous examination, my lord. This is immediately after this examination, recruitment examination 2016 to 17, and it's 17 to 19, my lord. The present is 7. Page 108, my lord. The extracted written marks statement of the candidate who were called for interview and finally selected by APS during the A civil examination 2016 to 17 are as follows, man. My lord, see at page, next page 109, my lord. Serial number 27, my lord. One so and so, he secured only 41%, my lord. He has been selected and appointed, man. He's not a PWD candidate. Again, my lord, 28 is so and so, my lord. She secured 47%. On my case, my lord, I've secured 48%. Now 29, my lord. So and so, 45%. And 30, my lord, 44%. These all even were, some of them were not even secure 45%, my lord. They have been appointed in previous occasion. And their appointment, this same person, my lord, their appointment orders 1010, my lord. Next. 110, my lord. Serial number 27, 28, 29, 30. As per later extract, my lord, they have been appointed.
Sir Tago?
Yes, my lord.
It is already 1 o'clock.
My lord, we'll continue, my lord. Deeply obliged, my lord.
My lord, I have a question for the private respondents, my lord. I will submit my on 11th, my lord.
Item number 1, judgment pronounced RSA 219 of 2015.
Appeal dismissed.
Item number 2, RSA 188 of 2024.
Appeal dismissed.
My lord, after having obtained the relevant document through RTI, it's found that I'm qualified in written examination, having secured 48%. Now, the previous occasion, previous succeeding year, preceding year, even below 45% they were.
What was the mark the only selected candidate achieved?
My lord. Yes, yes, my lord.
No, no. What was the mark? Who is the selected candidate had obtained?
My lord, here, my lord.
Only one selected, there was only.
Yes, only one
Yes,
candidate.
from
Against
PWD
yes,
category.
against. Now against PWD, only one has been selected, my lord. Although-
What is the mark she had obtained?
My lord, I have no grievances against her, my lord.
That's
that
all
part, my
right.
lord. My lord,
Can you tell me what is the mark she has obtained?
my lord, that part, my lord,
That information is not available with you.
my lord, my
Okay,
lord.
okay.
Only qualified list they have
Hmm.
published, my lord.
Hmm.
Page 59, my lord. Only
Hmm.
qualified. My lord, that is not because our the marks they have not mentioned, my lord.
Hmm.
Page 58, 59, this written examination result, my lord. 59 only. The serial number 144, my lord. Mark is not shown, my lord.
Hmm.
Now, my lord, since as in the advertisement itself, my lord have seen out of 60 posts, 5 posts is specifically reserved for PWD candidate, my lord. Now, in the OM 2008, my lord, it says, my lord, each vacancy. Now, this 5 vacancy is not for general, my lord. It's specifically in the advertisement itself, it's for the PWD candidate, my lord. They are trying to construe that this 5 posts reserved for PWD is not for PWD. It cannot be applied to the PWD. They are what they are contrary and arbitrary stand they are taking. I'll show their affidavit. In this case, the respondent number 1, APCS Arunachal Pradesh Public Service Commission, they have filed affidavit. You'll see affidavit. In the affidavit, what they say is they have contended that there's no special reservation, relaxation for PWD candidate. Although I have shown, my lord, in the later on part, I'll come to the act, rules, statutory rules framed by the government of Arunachal Pradesh and also statute, my lord. And in the advertisement itself, my lord, advertisement dated 4th July 2017, my lord. I've shown it, but there itself is the reservation, my lord, 5 posts and reserved. Now the contrary view they have taken, stand taken that there's no reservation for PWD. What contrary they have stand taken, my lord? My lord, you see their affidavit, affidavit of respondent number 1.
Yes.
Malad, first, Malad, para 2, I'll take Malad. Para 2, there are 2 part A, B, Malad. Your humble department beg to state that recruitment process of Arunachal Pradesh Service Commission before rendering its paragraph wise comment as follows, Malad. APCS follows the government office memorandum dated 7 July 2008. 8, Malad. For selection of candidate for written examination to Viva Voice. As per the memorandum, candidates are selected at the ratio of 1:3 post, subject to the securing 33% and each paper and aggregate 45%. I'm equally, I have crossed this limit, this cross, I have qualified, secure 48%. Now there says that as in each vacancy, the vacancy is now I'm harping on the vacancy in respect of 5 posts, This 5 posts is meant for PWD, Now, B, there's no separate rules provision for relaxation for any reserve category till Viva Voice text. Even for process of PWD, candidate, there's no relaxation in recruitment examination at written examination stage. The reservation of post is counted at final after Viva Voice. This rule is applicable to all the posts. Now, this is, it is contrary to the statutes, and it negates the very purpose and object of the reservation itself. Now, sum and substance. Now, next, their paragraph 15, With regard to paragraph shown, the writ petition, your humble department begs to state that APCS have been following this memorandum shown 2008 for selection of candidates shown. Same, it is reiterated, Now, if we go by the entire their sum and substance of the contention of the Arunachal Pradesh Public Service Commission, in nutshell, their entire contains that First of all, PWD candidate has to first compete with the general categories. If he succeed in competing general categories, only at the time of appointment, they will get reservation. This is what they are taking contention on, instead of the primary contention and whole contention of the APCS man. If it is the case, what is the purpose of keeping reservation in the advertisement itself? Now, advertisement itself, it is mentioned 5 posts reserved. Now, that is supported by the statutes, Right to Person with Disability Act 2016 and Rule 17, and State of Arunachal Pradesh has framed their own statutory rules 2018. Madam, I'll come to that part. Entire contention, madam. First, you succeed, compete with the general category. If you succeed in competing, then if you could come, then only you will get reservation. It is defeating the very purpose and object of act and reservation itself. It's just no meaning at all, my lord. The contention raised by the stand taken by the APCS, my lord. Now, in response to this, my lord, I've realized, my lord, their primary contention, para 2, para 15, my lord, of the APCS, my lord, response number 1, my lord. Now, in response to their affidavit, my lord, I filed my rejoinder also. But specifically, I have countered their stain, my lord. My rejoinder to respondent number 1.
Yes.
My lord, para 1, my lord. That with regard to the amendment made in para so affidavit of question, humble deponent beg to state that out of 60 advertised posts, 5 posts were identified and reserved for person with disability, and 55 posts were for general class of APST and general candidates. As per prescribed criteria, A is provided under office memorandum dated so, the candidate who secured 45 of aggregate total in written examination has to be called for viva voce test at the ratio of so, 1:3. Thus, the respondent commission ought to have called the 15 candidate against 5 posts reserved for PW candidate, and 165 candidate against 55 posts mean for general class of APSD general category candidates, which comes to 180 candidates in total, 160 plus also. Now, para 1.2, 1.1. But in the same case, respondent commission had only selected 1 candidate, namely so against 5 posts reserved for PWD candidate and 179 candidate against 55 posts for general class instead of 165 candidate, which ultimately infringed the fundamental right of the petitioner. It is pertinent to mention that as per this is, I've quoted the statutory provision of the Act, Section 33, 34, and rules. That rules are specific deal with subsequent state, and para 1.2, my lord. My lord. The aforesaid illegal conduct and act of omission on part of APCS per se illegal defeat the purpose and objective of the Right of Person with Disability Act 2016 and Right of Person with Disability Rules 2017. It is contended that once posts are identified and reserved in accordance with the Section 33 and 34 of PW Act 2016, the objective of such reservation cannot be frustrated by the APCS by adopting illegal recruitment process, which result in denial of statutory reservation, which would be nothing but only devised to defraud the PWD candidates against the statutory benefit granted under the aforesaid relevant provision of PW Act and PW Rules 2017. Thus, the submission of the respondent number 1 saying that no separate rules and provision for relaxation for any reserved category till viva voce test is wrong notion and misapplication reservation provision. Para 5, page 6, para 5. With regard to the amendment made in para 15 of the affidavit of opposition, your humble deponent begs to retreat para one so and so of this affidavit, and further beg to state that when the petitioner had already qualified in written examination, having secured 48% against 5 posts reserved for PWD candidate, he ought to have been called for a viva voce test by APCs and considered for appointment to the post of assistant civil engineer against the PWD reserve quota. However, in a most illegal manner, the respondent APC has set the competition of PWD candidate with other general class of APSD candidate against 5 posts of reserve for PWD candidate, and thereby reserve post has been illegally filled up by general class of the APSD general class, violating the statutory right of the petitioner. This is my rejoinder to the affidavit filed by the respondent number 1. Now, since at the earlier occasion, the respondent 1 misinterpreting the provision of office memorandum. Office memorandum is only administrative instruction, madam. It has no statutory force, madam. It's only mere guideline. Be that as it may be, madam. Since it was raised, contention was raised by the petitioner, the respondent 1, that there's no specific mention about reservation in the separate reservation for PWD, madam. Although in advertisement, it's clear-cut reservation is mentioned. Now here in this connection, my lord, this honorable court, by order dated 0208, the 2nd August 2022, because this office memorandum 2008 was issued by the Department of Administrative Reform. Therefore, clarification was sought from the concerned department by the order dated 0208-2022. To clarify the stain on OM dated 7 January 2000, issued by the Department of Administrative Reform, while filing affidavit. Now, my lord, in compliance with the order dated 2nd August 2022, passed by this honorable court, Department of Administrative Reform was impleaded as a respondent number 12, man, and they filed their affidavit. My lord, in their affidavit, they have categorically, respondent number 12, government have categorically stated that the OM dated 7 January 2008 is always subject to statutory act and rules, meaning thereby the OM dated 7 January 2008 cannot supersede the statutory rules. Madam, this is specific, madam, the order dated.
That affidavit is the word.
Yes, it is actually, madam, it's pursuant to the order dated 2nd August 2022. Now, affidavit filed by madam of respondent number 12. Respondent 12, affidavit filed by respondent 12. Filed on 28th September 2020. Part 12. Filed on 20 September 28, 2809 2020.
Yes, sir.
My lord, I beg to rely, my lord, para 4 of affidavit filed by respondent number 12, administrative reform. Para 4. that OM dated 07/01/2008 is always subject to the provision of Act rules. The right of person with disability Act 2016 and rule frame thereunder. That is Arunachal Pradesh Right of Person with Disability Rule 2018 provide that a person with disability act selected on their own merit without relaxed standard along with other candidates will not be adjusted against the reserved share, but the vacancy in the reserved category shall be filled up separately from amongst eligible candidates who are lower in merit than last candidate in merit list, who is otherwise found suitable for appointment, if necessary by relaxed standard. Now, next para 5, my lord. That as a matter of law and policy of the state government, the selection of candidate in the reserved category is always made among the candidate belongs to same category, subject to the merit as may be prescribed under recruitment rules. Now here, Arunachal Pradesh Arunachal Pradesh Right of Person with Disability Rule 2018, Madam, see at page 7 of this affidavit. They have annexed the rules also.
Yes.
It's called Arunachal Pradesh Right of Person with Disability Act Rules 2018. Now, my lord, relevant provision are relied page 10, my lord. That is Rule 12, Sub-Rule 3, my lord. Rule 12, Sub-Rule 3, my lord. And Sub-Rule 3 is at page 10, my lord. Rule 12, Sub-Rule 3, my lord. Sub-Rule 3 is page 10. My lord, I read. Person with disability selected on their own merit without relaxed standard along with other candidates will not be adjusted against the reserved share on a vacancy. The reserved vacancy shall be filled up separately from amongst eligible candidates who are lower in a merit than last candidate in the merit list, but otherwise found suitable for appointment if necessary by a relaxed standard. Now, Rule 12, Rule 14, my lord, down below, Rule 14, Sub-Rule 2, my lord. Rule 14 talk about reservation, 4% reservation, compulsory for all establishment in the government department. Rule 2, the post identified for each disability under Section 34 of Act shall be treated as a horizontal reservation, and the vacancy of the person with bench marked disability shall be maintained as a separate class. It's to be treated as maintained to be separate class. It cannot be equated with the general class. Now, what the respondent 1 is saying, you have to compete the first general. If you succeed in competing general, then only get reservation at the time of appointment. That is the arbitrary and illogical stand taken by the Arunachal Pradesh Public Service Commission. Then what is the purpose of reservation? Purpose and object of reservation. Now, apart from that, again, page 12, the Rule 18, there's a concession. If some case, even in the recruitment, if they cannot come to the benchmark for qualifying benchmark, in that case, 5% grace, the concession has also to be given. Page 12, Rule 18.
That is not your case.
My lord. That's not my case, but I already qualified. Even in that case, even this is not eligible, even 5% qualified, the mark concession has to be given. Now, I'll just refer the PW Act 2016, Section 33(1). Section 33.
Yes, section.
Section 33. Clause 1, madam. The
Section 30.
33, 33, madam. Let's talk about identification for reservation. Appropriate government shall, number 1, identify posts in establishment which can be held by the respective categories of person with benchmark disability in respect of vacancy reserved.
30?
33, madam. Section 30.
Reservation of post.
Yes, madam. Identification of post. Reserved in accordance with.
Identification or reservation, no?
Yes, reservation, madam. That is what, madam, in this case, madam, the post is already identified, reservation is done, madam. And section 34 talk about reservation, compulsory reservation, madam. It is statute, madam. Now they are saying that why I'm referring, madam. They say that there's no reservation. Now, the stand taken by is in violation of statute, madam.
There are two ways, perhaps.
Madam, one is
person with disabilities, equal opportunities, protection of right to full participation Act 1995 and
1990, this has been repealed, and this new act, 2016 is new act.
Gotcha. Yes, identification of post.
Yes, identification, madam, in terms of section 33, clause 1, madam. The post has been identified, reservation has been done, madam. Section 34 talks about reservation, madam. Reservation, and this reservation in advertisement itself, there's a clear-cut reservation of 5 posts. Now, subsection 2, madam, next page, 34, subsection 2, madam. It says, where any recruitment year, any vacancy cannot be filled up due to non-availability of suitable person with benchmark disability or for any other sufficient reason, such vacancies shall be carried forward in succeeding recruitment year. And if the succeeding recruitment year also suitable person with benchmark disability is not available, it may first be filled up by interchange among the 5 categories. And only when there's no person with disability available for the post in that year, the employer shall fill up the vacancy of the appointment of a person other than disability, person with disability. Madam, here in my case, madam, why I'm referring, madam, I'm already qualified, having secured 48%. Now it said when I'm qualified, why my case should not be considered, madam. They said that there's no reservation, which is contrary to the violation, contrary to the statute provision, contrary to the advertisement, condition of advertisement itself, madam. Now, therefore, madam, even if the benchmark, the person with disability is not available, and that the post reserve can be interchanged among the various categories, madam, of the benchmark, madam. Now, again, madam, we'll see PW rules 2017 and the same, madam, bear it only. Rule 11, sub rule 4, madam. Vacancy PWD shall be maintained as separate class, madam. It cannot be equated, mixed up with the general class, madam. Rule 11. Rule 11, madam, sub rule 4. The reservation for person with disability in accordance with the provision of section 34 of Act shall be horizontal, and vacancy for a person with benchmark disability shall be maintained as a separate class, madam. This is the respondent authority taking contrary to this statutory provision. Madam, in this regard, clarifying the statutory provision, madam, in my writ petition, paragraph 25 to 29, madam, I will specifically clarify my stand that if the stand taken by the government, that is the APCS, which is accepted, it will defeat the whole object of the act itself, madam. which is illegal and cannot be allowed to do. Para 55, 25 to 29, madam. Specifically, I have clarified my position in writ petition.
Twenty-five to fifty-five.
25 to 29. Para 25, 26, 27, 28, 29. With regard to the violation of the rules, man, and with regard and stand taken with them, man, it's accepted. It will be as good as having no reservation at all, negating very whole object of the act itself. And my lord, in their reservation, my lord, how the direction issued by the government, my lord, OM dated 21 of 6, 2012, my lord, there's a category say, my lord, even the specific how reservation has to be done, it is not even mentioned also, that will be governed by the Act and Statute. At page, my lord, 65 of my writ petition, my lord, talk about reservation. That office memorandum issued by administrative reform. Supposing there's a silent, then the act will prevail, my lord. Rules will prevail, statute rules will prevail, man. Now, my lord, just this is the whole sum of the fact of the case, my lord. Now I'll rely, my lord, some few decision, man, regarding the interpretation of PWD Act and the purpose. How the authority conduct the authority should be while implementing the provision of PWD Act, my lord. 2013-10 SEC. It's 3-bench judgment. 2013-10 SEC 7, page 772. Paragraph, my lord. Page 772, my lord.
Got it.
Paragraph 37, my lord. 37 and 44. 37, my lord. I'll just read it. Paragraph 37. My lord. Paragraph 37. My lord, admittedly, the act is social legislation enacted for the benefit of a person with disability, and its provision must be interpreted in order to fulfill its object. Besides, it is a settled rule of interpretation that if the language of statutory provision is unambiguous, it has to be interpreted according to the plain meaning of the said statutory provision. In the present case, the plain and unambiguous meaning of Section 33 is that every appropriate government has to appoint a minimum 3% vacancy in establishment, out of which 1% shall be reserved for the person with suffering from so with the various benchmark, my lord. My lord, this with regard to, in reference to the 1995, my lord. Now, para 44, my lord. Same interpretation, my lord, with regard to interpretation. Para 44. 37 and 44. It is settled law that while interpreting any provision of statutes, the plain meaning has to be given effect. If the language therein is simple and unambiguous, there's no need to traverse beyond the same. Likewise, if the language of the relevant section gives simple meaning, the message it should be interpreted in such way, and there's no need to give any weightage to the heading of those paragraph and quoted previous decision. This with regard to whatever interpretation is to be in favor of PWD for the purpose and object for which the act was enacted. Another decision, 2014 SEC, 2014 SEC 383.
2014?
14 SEC. 14 volume 14 SEC 383. Para 9. This is also 3 constitution based. No, it's a 5 constitution. Oh no, it's 3 constitution based. It's also 3 constitution based. Para 9. Be it as it may, the beneficial provision of the Act 1995 cannot be allowed to remain only on a paper for a year, and thereby defeating the very purpose of such law and legislative policy. The union, the state, union territories, and all those upon whom the obligation has been cast under 1995 Act has to effectively implement it. As a matter of fact, role of the government in the matter such as this has to be proactive in the matter of providing relief to those who are differently able. Approach and attitude of the executive must be liberal and relief oriented and not obstructive or lethargic. Little concern for this class who are differently able can do wonder in their life and help them stand on their own and not remain on the mercy of the other. A welfare state that India must accord its best and special attention to the section of our society which comprises of differently able citizens. This is a true equality and effective conferment of equal opportunity. Again, the 2021 5 SSA. This right has been recognized as a fundamental right.
Page number?
Page 370.
370?
Yes, 370. Para 41, 42 man. Part 2 of our constitution does not explicitly include the person with disability within its protective fold. However, much like their able-bodied counterpart, the golden triangle of Article 14, 19, and 21 applies with full force and vigor to disablement. The right of person with disability, the Act has been conferred as a fundamental right by this judgment. Article Act 2016 RPW Act seeks to operationalize and give concrete shape to the promise of full and equal citizenship held out by the Constitution to disable and to execute its ethos of inclusion and acceptance. 42. Fundamental postulate upon which the 2016 RPW Act is based is the principle of equality and non-discrimination. Section 3 casts an affirmative obligation of the government to ensure that a person with disability enjoy the right to equality, life with dignity, respect of their integrity, equality with others. Section 3 also affirmative declaration of the intent of the legislature that the fundamental postulate of the equality and non-discrimination is made available to a person with disability without constraining it with the notion of benchmark disability. Section 3 is a statutory recognition of constitutional right embodied in Article 14, 19, 21, amongst other part of the 3 of the Constitution. By recognizing a statutory right and entitlement on part of the person who are disabled, Section 3 seeks to implement and facilitate the fulfillment of the constitutional right of person with disability. 43, man. There's a critical qualitative difference between the barrier faced by the person with disability and other marginalized groups in order to enable the person with disability to lead a life of equal dignity and worth. It is not enough to mandate that discrimination against them is impermissible, that it is necessary but not sufficient. We must equally ensure as a society that we provide them additional support and facility that are necessary for them.
No, that is regarding how the provision of the act should be interpreted.
Yes,
that is all right.
This,
But
now, my lord, at page para 50, my lord, it has been treated as a separate class, my lord.
no, that's all right.
That's already
There is no dispute about it.
My lord.
But you tell me, this reservation when to be applied, after written examination or after completion of this written examination and viva?
My lord, I'll that part, my lord, I'll come to the. This is the horizontal reservation, my lord. And the horizontal reservation part also, I'll rely that this is the settled principle of law, my lord, of the Supreme Court. I'll rely that part also. Now, this, my lord, the previous occasion dealing with the person with disability, my lord, this honorable court has passed certain judgment, 2 judgments I beg to rely on. The first is, my lord,
it is not necessary to multiply the.
My lord. Now regarding, my lord,
when this provision of the act will be applied.
My lord, once it is qualified, my lord. Now it is undisputed that he is qualified in written examination. Now how this the horizontal reservation has to be done. Now, as per decision of the Rajesh Kumar Dauria of Supreme Court, it says that when there's a horizontal reservation, first you whosoever qualified, you just make a list and find out whether any of this special reserve category of person with disability is there in the list or not. If it's not in the list, then those bottom up to the extent of the reservation quota, from the bottom it has to be deleted. Then the person who is qualified has to be brought in. This is the settled principle of law, with regard to the how the horizontal reservation has to be carried out. Rajesh Kumar Dauria, this is 3-bench judgment, 2007, 8 SSC. 785. Paragraph 7 and 9. I'll read paragraph 7. A person for women, the person for women under the provision for women under Article 153, 15 sub clause 3, in respect of the employment is special reservation as contrasted from the social reservation under Article 164, 16 clause 4. The method of implementing special reservation, which is horizontal reservation, in my case, horizontal cutting across vertical reservation, was explained by this court in Anil Kumar Shonsho manner. The quoted para 18 of the Anil Kumar. The proper and correct course is to first fill up the OC quota so on the basis of merit, then fill up each of the social reservation quota so. The third step would be to find out how many candidates belonging to special reservation have been selected on above basis. If the quota fixed for horizontal reservation already satisfied, in case it is an overall horizontal reservation, no further question arises. But if it is not satisfied, the requisite number of special reservation candidates shall have to be taken and adjusted and accommodated against their respective social reservation categories by deleting the corresponding number of candidates therefrom. If however, it is the complemental horizontal reservation, in then the process of verification and so on so, and said above should be applied separately to each of the vertical reservation in such ratio. Now, para 9. Second relates to the difference between nature of vertical reservation and horizontal reservation. Social reservation in favor of ST, SC, OBC under Article 16, Clause 4 are vertical reservation. Special reservation in favor of physical handicap, women etc. under Article 16.1 and or 15.3 are horizontal reservation. Where a vertical reservation is made in favor of backward class under Article 164, 16.4, the candidate belonging to such backward class may compete for non-reserve posts, and if they are appointed to the non-reserve post in their own merit, their number will not be counted against the quota reserved for respective backward class. Therefore, if the SC candidate who by their own merit get selected to the open competition against equal or even exceed the percentage of the reserve for SC candidate, it cannot be said that the reservation quota for SC has been fulfilled. The entire reservation quota will be intact and available in addition to those selected under open competition. But the aforesaid principle applicable to vertical social reservation will not apply to the horizontal reservation, where a special reservation for women is provided within the special reservation for the scheduled caste. The proper procedure is first to fill up the quota for the scheduled caste in order of merit, then find out the number of candidates among them who belongs to the special reservation group of scheduled caste women. If the number of the women in such list is equal to or more than number of special reservation, then there's no need for further selection toward the special reservation quota. Only if there is any shortfall, the requisite number of scheduled caste women shall have to be taken by deleting the corresponding number of candidates from the bottom of the list relating to scheduled caste. To that extent, horizontal special reservation differs from vertical reservation. Thus, women selected on merit within the vertical reservation quota will be counted against the horizontal reservation for women. Let us illustrate by example. If 19 posts are reserved for SC, of which the quota for women is 4, 19 SC candidates shall have to be first listed in accordance with the merit from out of the successful eligible candidate. If such list of 19 candidates contain 4 SC women candidates, then there's no need for disturb the list, including any further SC women candidate. On the other hand, if the list of 19 candidates contains only 2 women candidates, then next 2 SC women candidates in accordance with the merit will have to be included in the list, and a corresponding number of the candidates from the bottom of the list shall be deleted, so as to ensure that a final 19 selected SC candidate contain 4 women SC candidates. But if list of 19 candidates contain more than 4 women selected on merit, all of them will continue in the list, and there's no question of deleting excess women candidate on the ground that SC women have been selected in excess of their prescribed internal quota. Now, this is matter at a time of now. The first they have to prepare the merit list. They have to examine whether among those merit lists the reserve candidate is there or not. If it's not there, then those bottom in the list, to the extent of reserve quota, has to be deleted.
That proposition of law is to be applied at which stage? After
exam,
completion of a written examination or after completion of the viva voce?
My lord, in my respectful submission,
their contention is that it should be applied at the end of the selection process, that is.
Now, my lord,
by-
in that case, my restoration, then what is the purpose of reservation, my lord? The reservation purpose and object of reservation is defeated because the PWD candidate, we cannot expect them to compete with the general category. If their proportion, if we accept that, you first compete with the general category. If you're successfully competing them, then only will get reserved. Therefore, my lord, their contention is misplaced, my lord. It's not according with the provision of statute. It's not according to the provision of law, my lord. Even category, my lord, in our Arunachal Pradesh right of person with disability rule 2018 specifically say that it should be maintained separate class. So once he's qualified, as per terms of advertisement say that minimum qualifying is 33 and aggregate it should be 45. Now petitioner has qualified in written examination. Now, well, written examination, my lord, well, preparing, enlisting the qualified written examination, they'll have to see, man, who else are qualified in the written examination from the reserve quota. And that, in that case, man, they'll have to adjust it, man. Otherwise, man, there's no purpose, and the very purpose and object of the reservation is negated. It's defeated, man. This whole purpose is to facilitate them, man, because they cannot compete with the main line, man, of the mainstream of the main man, people, man. That's why this special relaxed provision has been given. So this has been utterly violated by the authority. And if the contention raised by the contention advanced by the Arunachal Pradesh Public Service Commission is accepted, madam, there cannot be the person with disability cannot be get employment at all, madam. Because they are such a special category, madam, disabled person, madam. We're required to facilitate them. Now, you said instead of other words.
No, do you have any authority on that point?
Madam, that's why, madam, the two decision, madam, of this coordinate bench, madam, 2014. 2 GLR, madam. 552, madam. Para 2 talks about the fact, madam. Here also, madam, petitioner applied being PWD candidate, but his name was not.
Which paragraph is
madam, the fact is to, madam, I'll be relying on, madam. Para 5, madam. Last, madam, the fact, madam, exactly like present case, madam. Petitioner applied for, but his name was not enlisted in the list, madam. Then approached, madam, after obtaining report.
Which line it is?
Madam, that's the 6th line from bottom, para 5, madam. 6th line from bottom. The fact that, madam, fact that petitioner is physically handicapped person is not in dispute in the case. This case, the state respondent have conveniently overlooked the case of petition apparently to make way for some favorite candidates. On the fact found by me, I am thus of view that the petitioner has made out a case for the interference of this court. Resultantly, 6. This writ petition will succeed the respondent state directed to consider the case of petitioner for a post of and if necessary by creating supernumerary postman, because fault is committed by them. This is, madam, one, madam, again, madam, 2016 3 GLT, madam, JLR, madam, 2016 3 JLR. But one to talk about the fact, madam. Here also, madam, same. He participated in the recruitment process. His name was not published in the result, my lord. On this factual background, my lord, para 7, 8, 11, my lord. Para 7, 8, para 7, 10 and 11. Para 7.
Para 7.
Para 7, my lord. Para 7, 10 and 11. Para 7, my lord, I'll read. At the outset, my lord, I'm constrained to observe that the benevolent legislation like person with disability, so and so, has been allowed to remain, my lord. So and so, recording the Sunanda Banana family case, my lord, that I relied, my lord. Role of government in the matter such as this case has to be proactive in the matter of providing relief to those who are differently able. The approach and attitude of the executive must be liberal and relief oriented and not obstructive and lethargic. A little concern of this case, of this class who are differently able can do wonder in their life, so and so man. Now, this is the extract, citing the Sunanda Banana Foundation case, man. Now, next page 10, man, para 10, man. Judgment of National Federation of Blind Supra has to be extensively reproduced by me so that decision maker must correctly understand the law that regulates his decision making power and must give effect to it. After all, knowing the real nature and extent of reservation made for a differently able person is immense importance. In the instant case also, the respondent authority are either probably not aware of the aspect of the law or have differently or have wittingly or have deliberately ignored it to circumvent the law, either by other way or they have unwittingly flouted the legislative policy and legislation by not accommodating the petition against one post of assistant teacher so and so in the There's no question of name of petition not falling within the zone of consideration. The petitioner obviously entitled to be selected against one post of assistant teacher, upper primary school, so and so, so and so, in terms of provision of section 33 of the Act. It's evident from the final select list that no physical candidate person has been selected or appointed. For example, as per office memorandum so and so issued by central government, inter-se exchange and carry forward of the reservation in case of direct recruitment is permissible. Reservation of each three categories of the person, namely person suffering from blindness or low vision, hearing impairment, so on, so on, shall be made separately. But if the nature of vacancy in establishment is such that the person of a specific category disabled cannot be employed, the vacancy may be interchanged among the three categories with the approval of so and so. But this is how, basing on this, citing this. That's relevant, madam. In action of respondent authority, not in selecting candidate for appointment of post of assistant teacher against the quota reserved for candidates suffering from locomotor disability is therefore arbitrary, contrary to the provision of Act, as no other reason is advanced by the respondent authority, and reason given by them to deny the appointment are found to be misconceived and do not have leg to stand. On this case, there's a positive direction where positive direction can be issued to them for issuing appointment order of so and so. Para 11, for that, what has been stated and foregoing, this representation succeed, ma'am. Directing to consider the case. My lord, only my lord, it may not be required to even my lord rely. It is a settled principle law that office memorandum cannot overread, my lord. Rather, statutory rules, my lord. That has become settled. I believe that it will not be disputed, this legal position, man. This, although Office Memorandum 2008 is in my favor, my lord, but what the interpretation they're taking, that since it is silent, but even if silent, the subsequent 2012 office memorandum, it has been clarified. If it is silent, then the act will prevail, my lord. That is, my lord, becomes settled, my lord. One thing, my lord, regarding, my lord, if particular thing to be done in particular manner under statute, it has to be done. It has to be done in such a manner, my lord. Otherwise, entire exercise will be illegal, my lord. 2014 2 SSC. 2014 2 SSC 401. Para 34. Para 34.
Yes.
Yes, paragraph 34. There's yet an uncontroverted legal principle that when a statute provides for a particular procedure, the authority has to follow the same and cannot be permitted to an act in contravention of same. In other words, where a statute required to do certain thing in a certain way, the thing must be done in that way and not contrary to it at all. Other method or mode of performance are impliedly and necessarily provident. The aforesaid settled legal proposition is based on legal maxim expressio unius as exclusio alterius, meaning that if the statute provides for a thing to be done in a particular way, then it has to be done in that manner, and no other manner following other course is not permissible. This is now here, the statute clearly provided in my favor, rules thereof, central government rules, statute passed by the parliament, and also the rule framed by the state government of Arunachal Pradesh. It's in my favor, madam. When it is, there's clear-cut and no dispute. There's no confusion with regard to interpretation and application of law, madam. How they take the respondent authority can take pleasure state, the stain, which is contrary to the law, madam. Even their advertisement against the advertisement itself, madam. This is in my. That is why my respectful submission. Since although there's one post already reserved, kept vacant by virtue of the interim order, my lord, and the post reserved for is PWT is 5 posts, out of which only 1 candidate has been selected, and 4 posts remain, my lord. In that case, applying the ratio laid down by the Rajesh Kumar Doria, my lord, the horizontal reservation and procedure thereof, my lord. But person who are in bottom are that related, and the qualified PW candidate has to be taken in, has to be adjusted, madam, taken to the least, madam. So in my respectful submission, madam, since the petitioner, madam, although in other, madam, in the case the Manipur Public Service Commission, madam, there's a decision saying that a particular person approached the court, madam, his case should only be considered, madam, applying the principle of doctrine of pen-sitter, madam. Person who has not approached, they should not get benefit, madam. In that case, if this ratio and the principle is applied, madam, my case is covered, madam, because 1 post already laying vacant, madam. Madam, if they PCS agreed, madam, the ratio laid down by the Manipur Public Service Commission is the judgment authored by the Koteshwar Singh, madam, wherein say that person who vigorously approached the court, at least that fruit of justice
No,
should be.
no, there are judgments of Supreme Court that if the proposition of law is laid down,
Yes, madam.
it shall be applicable to those persons who have not approached the court also.
That is also there, madam. That is also not that is.
So according to me, this decision may be pardoned to them.
My lord, that is why, my lord, if accepting, since one post is clear cut vacant, my lord, is already there by operation of interim order, and the 4 posts, my lord, has to be adjusted. And when we are qualified, madam, I am qualified as per advertisement, as per criteria, my case should be considered against those 4 vacant posts reserved for PW. That is my respectful humble submission, madam. Present.
Yes, for the respondents.
I'll address after government.
After government. Okay.
Yeah.
Secretary. This is So, all the parties are represented by their English counsel. Part in part, list the matter on when? 11.
Item number 19. Madam, this is appeal against imping order of judgment attempt, madam. 29/8/22, filed by the civil judge, senior division, Pasigat. In money sheet number 5 of 50. Madam, in this, madam, I agreed on the judgment at the 28/9/2022. As because, madam, as per the OP, money sheet number 5 of 14. She claimed that she is entitled to get entitled to get 40 lakhs 94,000. Which is at page number page number 46. Annexure C. The basic claim of the OP on his money sheet is that, which is in para 2 of page number 48 of their petition, money sheet petition. In pursuant to agreement that is executed between the dependent, who is right now appellant, and the Mercantile Riba, who is the OP, plaintiff was permitted to start a construction on foundation wall of JNB Pasigat East District in month of 2012 due to some technical problem. Agreement in between dependent and Mercantile Riba was cancelled, and press agreement was executed on 15/11/2012 between
preventive and dependent with Tasubo. On this strength of this agreement, he filed a money suit against me. And during the trial, the PW of PW number PWK Riba clearly stated who is the witness in the agreement dated 15/11/2012. Clearly stated that he was not present while executing the agreement, where the appellant
Where is that agreement?
kindly came 57.
Page number?
Yes, yes. No, not this one. In page number 59. 59. On this instrument, OP has said that he has been permitted to do work after cancellation of agreement dated, which is page number 57. 18/12/2011. Actually, fact of the case is that on 18/12/2011, I entered agreement with Kentariba, where I authorized her to do work on my behalf. But without my consent, without my knowledge, Kentariba has been assigned the said work to the present OP. What he claimed, and he started the work. Thereafter, there was an agreement which he claimed that there was agreement on, which is in page number 59.
This agreement bears the signature of both the parties?
No, that's why I'm saying that. In page number 59, which agreement he stated that on that agreement, he has been allowed to do work by the appellant. So in this behalf.
No, both the parties signed this agreement?
Well, no, my lord. As per evidence, it was no. No, 57, yes, 57 was there. In 57, yes, it is true.
Both the parties signed
Yes. Actually, what was, and if we see the page number 59, with regard to page number 59, kindly page number 131 of my petition, where PW has clearly stated in page number 131 of my petition. 31.
131.
Yes, while cross the PWs. Who is the vital witness in the agreement that
No, maybe, but this agreement bears, whether this agreement bears his signature or not? The witness? Yes, 3 witnesses are there. Page number 62.
62.
Mrs. Kendra Riba, Kirkar Riba,
No.
and Bomrik.
I am disputing the signature. I was not present on that day with this agreement. And on this strength, kindly page number 131, kindly come to page number 131, the cross-examination of PWs. Who is the witnesses in page number 62?
130?
131. Here it says that on 1, 2, 3, on third line of from bottom, it says that I admitted that during cross, Chikubablu was not present on dated agreement dated 15/11/2012, meaning thereby on page number 59, that agreement has been not signed by the appellant, meaning thereby he has been not authorized to the OP to start the work.
No, you see, this agreement bears the signature of that person, Sukubablu.
Yes, but I'm disputing this agreement. I was not enter in any agreement with the OP. During my,
Whether the admitted signatures were sent to the FSL.
no. But it has been substantiated by the PWs also, that he was not present during the execution of the agreement, which is in page number 131. And even, my lord, in judgment, even, my lord, while passing an impugned judgment, in issue number 2 also, the learned civil judge has clearly stated that there was a negative on the part of the issue number 2, which means there was no any agreement between the appellant and OP on dated 15/11/2012, which is at page number kindly page number, come to page number 30 of judgment of my petition.
No, she merely stated that while she put her signature in the agreement dated 15/11/2012,
Yes,
that Suku Babu was not present at that time.
meaning thereby no agreement has been done on that day.
Pardon?
Meaning thereby on that day, 15/11/2012, there was no agreement executed between.
No. That kind of meaning cannot be given to the evidence.
No, my lord, if we see the judgment also, my lord.
Evidence cannot be interpreted. It has to be read only.
No, my lord, if we see the kindly, my lord, page number 30 of the
Page number?
30 in issue number 2, where civil judge has been decided on issue number 2,
Page number 30.
30 of my petition, and on issue number 2. Issue is here that whether any agreement was executed between the plaintiff and the defendant. Mean plaintiff means OP here and dependent I'm on 15/11/12, and if so, the same pursuant the agreement dated 18/12/2011 between the Kenta River and the dependent one. In this issue, the civil judge has been affirmed the negative on that, meaning there was no any agreement as per evidence. Which is in page, on conclusion, which is para 43 of judgment and page number 33. Page number 33, yes, para 43 of the judgment. The burden upon the dependent number 1 will be shifted only when the plaintiff has made out a probable case. But in the absence of any evidence to show that dependent number of signing the agreement between dated 15/11/12, even at the later dated, it cannot be held that the agreement dated 15/11/12 exhibits supersede the earlier agreement dated which was still valid, meaning thereby earlier agreement which was on which is on page 57 has been not been superseded on agreement dated 15/11/2012. Meaning there was no authority has been given to the OP to start the construction of the work. Meaning there was the agreement dated 18/12.
Then on what basis the trial court has decreed the suit?
The fact of agreement between dependent 1 and Chuku Bablu, para 14/32. Para 40, page number 32. Fact of agreement between dependent 1 Chuku Bablu and Kenta Riba that is, as mentioned by the plaintiff, is not disputed. Stated the first agreement was cancelled without the consent. My lord, in here, the dependent, sorry, OP witness itself stated that he was not present during execution of agreement. And in judgment also in issue number 2.
No, that's why I'm asking you on what basis the trial court then decreed the suit
The trial
in
court,
favor of the plaintiff.
trial court was on favor of the plaintiff on mere of the agreement dated which is page number 95. And this is not a suit amount. Page number 96 is a type of number.
Original, it is the original agreement.
Yes. The fact of the case is, my lord, here that this is before the filing of the agreement, and on that also we was ready to pay that amount, but the OP didn't listen and filed a money suit, money suit against me, claiming of rupees 40 lakhs 94,000. That he eligible to get more than this amount. So, my lord, here in this case, civil court senior division has tried to balance the both the parties without applying the law. Just on, if we see judgment of the, if we see judgment of the civil court senior division.
Page number?
Uh, 75. Number 43. No, page number 43. My lord, come to the page number, sorry, para 74 of the page number 43. First, here it says that that agreement could have clearly mentioned that liability dependent on one and the plaintiff and his.
No, you see, but it the observation in last part, but it appears that both sides have voluntarily agreed to mention about 14 lakh.
Yes, that is it.
46,000.
That is it. On that basis only, my lord.
If
On that basis only, my lord.
you have agreed. So if it is a consent decree, whether appeal will lie?
No, my lord, here that actually, my lord, fact of the case is that this matter is filed on 2014. And before that, I was agreed to pay, but he denied. Thereafter, what happened? They dragged this matter to up to 2022. And 22 is on that during trial, they have 5 miscases to drag this case. Therefore, this has been so lengthy. And right now, my lord.
First and foremost thing is this is a consent decree. And no
No,
appeal
no,
lies
my lord.
against us.
No, my lord. This decree is on contest. This is on contest, my lord.
No, this observation indicates that it is a consent decree. You see, but it appears both
My lord,
both sides have voluntarily agreed to the mentioned amount of rupees 14,46,757 rupees. What remains there?
12%.
Huh?
12%.
Which?
Actually, my lord, I'm agree with
But
the
the court
interest.
has awarded only 6%. 6%.
My lord, if we see page number 18. My lord, come to the page number, my lord, 18 of my petition. It is clear mentioned that the case is disposed on contest, not on me.
Maybe that may have mentioned, that may be there.
This
But this line, this last paragraph of section of the paragraph number 74.
My lord, here we are not disputing the 14 lakhs also. We are agree the interest rate, which the
interest is only 6%.
6% from the filing of the suit, not from the decree of the suit. That's why, my lord, if we counted that, then it's equivalent to that 40 lakhs. It agree because this case is not delayed by us. If we see the if we see the documents of the trial court.
So you are ready to pay from the date of decree, not from the date of filing of the this plaint.
Yes, my lord. We already deposited 14 lakhs also. We are ready to pay 14 lakhs, but we agree on that interest rate of the from the filing of the suit only, my lord.
No, usually from the date of filing of the suit, not from the date of decree. In the case of this MSCT cases also, from the date of filing of the claim petition.
No, my lord,
So,
because
that is the principle.
Justice has to prevail because this matter will not break because it evident that we have agreed before the filing of the suit. In the position also, it is.
So dispute is only between this
Interest.
interest.
Yes.
From the date
Filing of the suit.
filing of the claim petition and from the date of decree.
Yes.
In between. That
Yes. That is, yeah. Because if we,
Mr. Tara, can some concession be given to him?
Yes, firstly, the concession will come at the second leave of any dispensation of justice. What they have admitted, my lord, can we come to page 10? Ground F, my lord, of the petition. This has to be read conjunctly with paragraph 74. That the appellant begs to state that the learned court below has committed grave error in law by passing the decree amount not on basis of claim amount of the respondent as per his suits. Rather, the decree has been passed by learned court only on admitted amount by both the parties. Now that means once it is a consent decree, then appeal will not lie. That order 41, Lord. Now read with section 96 and sub rule 3 is very loud and clear. So first, even if for the concession, he has to satisfy this court on law point, Milord. That
no, without going into the law point, can some concession be given to him?
Now, Milord, in any case, Milord, kindly see, my lord will also appreciate order 23, Milord.
No, that's all right. Law is there.
Order 23
Law is there.
is also
I am offering you without going to the relevant provision of law. Law is there.
Milord, because for that, because
what is the time period from the date of filing of the suit till disposal of the suit? Only
No,
the date
no,
of
Milord. In terms of procedure and the MSCT procedure that we follow, it is from date of institution of the
no,
suit.
that's all right. That's all right. What is the time period? In between,
8 years.
8 years.
8 months,
8 years.
8 years.
Yes, and during that 8 years, they filed 5 miscases only to drag this matter. Otherwise, it could be settled at earlier 2014.
My lord, 1 year I can give the concession. I can convince my client forgo 1 year. Else, my lord, legally it is not tenable petition.
Legally not
Legally,
correct, that's all right.
Because
That's all right.
just I'm taking my own risk. Otherwise, I was going through one of my lord's judgment only recently. And that I thought it prudent that 2022 5 SCC page 449. Unless, my lord, if there is unless if there is no misrepresentation or the fraud, if the consent, if the decree is passed on the consent of the parties, then this appeal must be dismissed in limine only, my lord. So then, like, okay, you come back tomorrow with your client. And I'll also come back tomorrow, my lord.
Yes. Yes.
Otherwise, my lord, legally,
Legally, you are not entitled
My lord,
to get any concession.
This can be posted on 18th of this month.
no, 18, I'm not there. Tomorrow, my lord. Tomorrow, if my
Because,
brother can come tomorrow,
on
you
that-
come. No, you only come. The council has taken the risk that he can request the client to forego for 1 year of the interest. And then else, my lord, I will have to argue on the maintainable, on the merit, and merit if your case is not maintainable, my lord. I was
My lord,
listening to you very
if
clearly.
we see
because the young council, my lord, they should always be given fair chance to argue. So I have given enough time.
My lord, from my understanding, this is not a consent decree. This has been contested.
No. Paragraph 10, you see, 10.
But
page 10,
though it was
round
admitted, my lord, it was admitted during the prosecution evidence. It was admitted that there was an agreement, but it was on contest. The decree was passed on contest only. Otherwise, it could be settled before finalization of this money shoot, my lord. And whereas it is clearly said that this matter has been disposed on contest only, and it cannot be considered as a consent decree. This is my humble submission.
No, my lord,
So,
even that page
despite-
131.
Despite that, my lord, my only simple prayer is that my interest may be considered. Interest rate that which is because this matter is delayed due to their only, not my fault. Because they have, if we see the report also, they filed 5 miscases, which take 3 to 4 years to
That's what I
dispose.
said. They may file any numbers of miscase. There is no bar.
My lord, justice has to prevail so that,
cannot
my lord,
be.
because delay, court has to see who has done delay, and it was not from my side, my lord. And I'm not saying that I will not pay the 14 lakhs. Already I deposited before the court also amount. But only issue is this, that the interest which is given from the filing date, if we consider the filing from the institution of the filing, then it will take 8 years. And if with the 6% interest per annum from the 14 lakhs, then it's equivalent to 24 lakhs.
Well,
Which is
probably the order, the learned trial court has passed this order as a consent decree in terms of page 95 only, page 95 and 96. Yes, I was recalling this 4114. I see so and so, proprietor of so and so, agrees to pay. And that means, it comes under definition of section 2 of the CPC.
And this document has been exhibited before the
Yes,
trial court?
yes. And my lord, kindly see, had he had not paid this money for 14 lakhs 46,757 only through check under 30 days from date of this agreement. Then and will also agree to pay part payment of 3 lakhs on Monday, 3 lakhs. If above conditions are not fulfilled, then Mr. Tasso Boran can stop work. Meaning thereby the course of action has arisen from here only. And then first you make a promise, then you did not fulfill, then section 10 of the Contract Act will attract. So I think In any case, please come back tomorrow. I'll request my client whether he can give a rebate of 2 years or 1 year.
Yes, yes, yes.
I mean, at least, well, this is a case not to be agitated, but on law, you do not have the case and your petition will have to be dismissed. Otherwise, I have to place the authority. You go back, please have a consultation, or you can speak to your client right now. Or come back
My
tomorrow.
lord, so on that case, my lord, I may be given some time so that my.
But then
senior will
interim
appear.
order has to be vacated. There is a stay out. That's why, my lord, I was pressing that day because
But any amount was deposited?
Yes, already deposited. The 14 lakhs already deposited before this honorable court.
Before the court?
Yes. Decree amount has already deposited. There are no disputed.
No, by tomorrow you obtain the instruction.
You speak to your
Okay,
client.
you move to dispose of the petition. Dispose of this appeal.
Otherwise, it has to go on merit, my lord. That I am already.
And even if you go to any higher forum, I don't think that you will get any relief because this agreement is there.
My lord,
And my lord,
95.
my lord, in the appeal, RFA only, page 10, my lord, ground G. Your own volition of admission, my lord. So because you cannot blow here now. Even it cannot be in the form of fly by night now. It is
You
on oath.
cannot approve it or reprove it at the same time.
Probate and reprove.
This paragraph number Z.
Yeah.
It is your own petition. You have admitted here.
Sorry, please speak to your client. Come back tomorrow.
Tomorrow.
But I can take a risk for
Both
1
the
year.
parties are.
No problem.
Mr. Tara, you see, can he go to more than 2 years or?
Well, I'll speak because this is an engaged case. Normally, you know.
Legally
it's
may not be correct, but even then.
Even if, my lord, on that judgment, if I place my lord passes, even Supreme Court will not interfere in this matter. That is my finding.
Both the parties are represented by their engaged counsel. Part in part, lays the matter tomorrow.
Correct. Grateful.
Obliged.
May I please, your lordship? My lord, this is also, my lord, one, my lord, of the writ petitions, my lord, wherein, my lord, the urgency is there, my lord. My lord, I was terminated, dismissal from the service on, my lord, the wrong findings of the, my lord, the department, my lord. So therefore, my lord, at this stage, my lord, I'll just go through the facts of the case and, my lord, lords, entire thing is, my lord, on record in my writ petitions, my lord. And basing on that, my lord, my lordship may dispose of the matter. And that is because recently my wife has also died, my lord. I'm nowhere, my lord. And on the, my lord, humanitarian and on leniency ground also, my lord. If my service is, my lord, restored and reinstated in the post where I was terminated, my lord.
On what ground you are
My lord,
terminated?
findings was, my lord, basically, my lord, what depends just in nutshell, my lord. Petitioner was serving as a constable in the Arunachal Pradesh battalion, APP BN, and during his service, the posting, one UTP escaped from the UTP sale, and I was the constable at that relevant point of time. Above me, altogether, 6 or 7 officers are there, initially, when the UTP escaped from the prison.
So departmental proceeding was drawn up against you?
Yes, madam. Yes, madam.
So is there any infirmity
Yes,
or
madam.
illegality
Infirmity,
in
madam.
the
Madam, basically, madam, initially 3 officers were with me, madam, 2 officers were suspended, reinstated, madam, revoked, and they were peacefully serving. And in the department proceedings, madam, basing on the wrong findings of the inquiry report, madam, my first ground is, there is an infirmity in the findings of the department, the DE,
How?
That's because I was not the alone responsible, at the relevant point of time, number 1, At the relevant point of time, it was, if we say, my lord, it is this supervening.
No, you show me how the inquiry report is informed
Yes,
of
ma'am.
illegal.
So therefore, my lord, and except, my lord, firstly, when the UTP was escaped, report was given, my lord, I'll not go into depth, my lord. Annexure 1 is the FIR, my lord. And Annexure 2 is the suspension order, my lord. I, along with my lord, 2 officers were placed under suspension, subsequently revoked, and we were, my lord, peacefully serving in the department, my lord. My lord, this is Annexure 3, my lord. This is the, my lord, the preliminary inquiry at the relevant point of time when the, my lord, the accused, my lord, the UTP escaped from the cell, my lord. This is the first, my lord, the preliminary finding, my lord. My lord,
At page number?
Page number, my lord, 33, Annexure 3, and the relevant portion is 34, my lord. My lord, may kindly, my lord, note of the page number 34, where paragraph, my lord, are given, paragraph, my lord, 34 is the relevant paragraph, page, my lord, and, my lord, 35, my lord. My lord, paragraph, page number 34, second paragraph, third paragraph, fourth paragraph, fifth paragraph, all are, my lord, relevant, my lord. If, my lord, my lord, I'm reading.
This is preliminary inquiry.
My lord, findings of the preliminary inquiry, my lord. In that, my lord, preliminary inquiry, it is
On the
not.
basis of preliminary inquiry, you have been dismissed for service.
After that, my lord, the regular
Final
departmental
regular inquiry conducted.
Yes, my lord.
So then let us go to the regular inquiry.
Regular inquiry, my lord. Regular inquiry, my lord. Page number, it starts from page number, my lord, 36, my lord. Article of charges 35(7), 38, and 38 is, my lord, the constable, my lord, serial number page. I'm reading page number 38, serial number 3, constable Suraj 3. That constable so and so, APPL so and so, while posted at Itanagar Police PS on 15 January 2007, was detailed for the guarding the UTP sale with effect from 2000 hours to 6 hours in the intervening night of 16 January 2027, 2007 at PS Itanagar, not only failed to perform his duty properly, but helped the UTP Gangte Tagung to escape their custody. B. The Suraj constable so-and-so during his duty hour used to go out of the cell often, during which cuttings of the ventilator rods of UTP Gangte Tugum was carried out. He was given one pair of the police uniforms to UTP Gangte Tugungs with a view to facilitate him to escape from custody under the guards of a uniform personnel. And taking advantage of such facilitation, UTP Gangte Tugung escaped from the custody. The above all facts of all acts on the part of the Constable Suraj Chetri amounts to serious misconducts for which he is liable to be dealt with departmentally under Rule 7 of Arunachal Pradesh Discipline, Pradesh Police Discipline and Appeal Rules 2099. This is the charges. On that findings,
How many witnesses have been examined?
Altogether, most of them are not relevant, my lord. Altogether, 7 to 8, my lord, witnesses were examined, my lord. And defense statement, my lord, is my page number, my lord. Defense statement, defense statement is at, my lord, page number 42. Just, my lord, page number 42, below, my lord, serial number 1, my lord. That then SP Papumpare in the report has stated that the cuttings of the ventilator was going on the last 1 to 2 months. 1 to 2 months it took, my lord, to cut the ventilator. 2, my page number 43, my lord. Whereas UTP Krishna Sarma, PW, the states that the cuttings of the ventilator grill was less than 15 days from the date of escape. they were contradictory. They are contradictory. I have been charged with the proving one pair of the police uniforms, which I strongly deny. The charge is absolutely false. I neither saw nor heard the sound of the cuttings of the ventilator's grill by UTP Gangte Tugum, and I strongly refute the charge and the statements of the UTP Krishna Sharma. However, I confess the following. A pair of boot was given by me to one UTP Devya Bashumatiri at his
So that UTP Krishna Sharma, who fled away?
Gungte Tugung is the accused persons who was
Gangte
Gungte
Tagung.
he escaped from the prison. Madam.
And what is the statement of Krishna Sharma?
Krishna Sharma was one of the prisoner. Madam. Madam, I refuse. Madam.
So where are the evidence of the witnesses?
Witnesses, Madam.
This is your statement.
Yes, Madam. Now, Madam, statement, Madam, the statement introduction, Madam, page number 44, Madam, annexure 7.
So who is witness deposed against you?
Madam, witness is Krishna Sharma, Madam, again, page number 48, Madam.
Page number 48.
Last line, Madam. Madam, I'll not read the entire things, Madam, just fourth, fifth line. UTPs were cutting the ventilator not less than 15 days from the death of the escape. He showed the police uniforms the day of the escape and also seen the mobile phone, mobile 2 to 3 days before the escape. He stated that he had seen the uniform, which was provided by Constable Suraj Setri, petitioner manager, jailer. He further stated that he had also noticed that both Gangte Tugungs and Divya Basumati used to drink inside the UTP cell and empty bottles were handed over to Suraj Setri, jailer, to dispose of. He also stated that the UTP used to cut the ventilator mostly during the night, during the duty hours of the court. Important part is, during the duty hour, man. He never stopped from the cutting and the ventilator. He had also saw blade and ventilator, but where from it was provided, he does not know. The on-beam cross-examinations by the charge officers, Sri Suraj Setri, this PWD clarified the Suraj Setri jailer on 2 or 3 occasions have thrown the liquors bottle and have not stopped the UTP from cutting the ventilator if he, jailer, had heard the cutting. On being cross-examinations examined by this so-and-so and so-and-so regarding checkings of the UTP cell on regular basis, this PWD clarified that OC used to check the UTP cell on regular basis, and Sri Inya also used to check the UTP cell when ever he was on duty. I am not the only constable who is guarding this UTP. Above me, inspector, deputy inspector, even SP, and the regular at that relevant point of time, Inspector R. Monpa was the officer in charge. Inya is the second officer who is above me.
So the statement, complete statement of the witnesses are not available here. Madam, the record is available with you.
Record what never follows.
Statement of the witnesses will be required.
Statement of the witness.
These are these are the appreciation in the proceeding. DP report.
Admittedly, at the relevant point of time, no, at the very instance, LCR was not called for. However,
The record of departmental proceeding, the statement of all the witnesses will be required.
Only one, is he, Constable Sharma, he only gave his statement against me, only because whenever he demand for
That's all
the
right. Why should we disbelieve him?
Madam.
Why should we disbelieve Constable Sharma,
Yes,
who
ma'am.
has implicated you?
Disbelief, as I pointed out, at one point of time, he demands for the liquors, but he throw the liquors. Why you are insisting for the providing the liquors? Then that quarrel, it happens openly in the UTP sale. So if one accused person is not providing anything which he demanded, if not provided, then that will go against the officer in charge.
Maybe, but this statement of this witness.
Witnesses, rest
Krishna
witnesses,
Sharma-
rest witnesses. Only he, the only person who gave the statement against me.
But we have to see how he was cross-examined,
Madam.
whether his statement, his evidence in examination in chief was rebutted in cross-examination or not.
Madam. That is one aspect regarding findings of contrary findings. The initial stage, initial inquiry was not taken into consideration.
Where is your defense statement? Page number?
Page number, my defense statement. Thereafter, the findings, other witnesses are not against me. He is the only person who is giving his
No,
statement.
you show me your statement. Page number?
My statement is
Defense statement. Just before sometime you have shown it.
Page number 42,
42, yes.
Yes.
Where you have stated that Krishna Sharma has implicated you falsely.
By that time, it was not clearly made the statement. Just for a moment, may I read the second paragraph? On 15 January 2007, I took over the duty of the jailer at PS Itanagar from the constable so and so at so and so hours. My duty was from 8 p.m. to this is the way. So and so on 16 January 2007. I was performing the duty of the jailers at PS Itanagar since August 2006. We were four personnel performing the duty. This is important. Four personnel performing the duty of the jailers in rotational basis. On 15 January 2007, at so and so hours, I took over the charge. I checked all the UTP cells from outside and found nothing fishy. I had checked them from time to time. I last checked the cell at 2 a.m. on 16 January 2007. Thereafter, I sat on the bed of the jailer's rooms to take rest, and since I was already awake, keeping the sharp vigil with my eyes revealed over the UTP cells, and unfortunately, I got dose of being continuously awake for the last 6 hours on that night. Only at about 6:15 hours on 16 January 2007, one UTP Krishna Sharma called me and informed that UTP Gungte to Gungte escaped from the UTP cell number 4, where they were lodged. I then immediately reported the matters to the night duty hour officer, SI Sri I Ate, who took follow-up action. In this regard, I beg to submit that the charge that I helped the UTP charge Tugung to escape from the cell is entirely false, and that I strongly deny it. I have never done so. The charge is absolutely false, and I am being made a scapegoat. The following facts may be fair used and considered over. 1. Daden SP Papumpare in the report has stated that the cuttings of the ventilator grill was going on at the last 1 to 2 months. This is the findings of the my statement, defense statement. Now, my contention is not basing on the preliminary inquiry done by the
No, here you have not disputed the statement of Krishna Sharma.
Thereafter, the charge was framed. So cause notice was given to me, page number 9, sorry, annexure 9, page number 58 is the so cause notice after inquiry.
So your
so cause notice was served to me, my lord, by
no, that's all
deputy
right.
inspector.
Your finding is only based on the statement of UTP Krishna Sharma.
Correct, my lord.
So we have to see the statement of the witness Krishna Sharma, and we have also to see how you have been able to rebut his evidence.
Yes, my lord.
Hmm.
And my lord,
And
just
that
for-
statement is not before the court. Let Madam Ite to produce the file of departmental proceeding.
Yes, Doctor, this is dismissal case. Of course, in other minor punishments also, the record has been called for, and accordingly, there were.
Case was, thereafter case was dismissed. Let the record come.
Record will be.
my lord. My lord, may I pray?
When you will be able to produce it.
Subject to convenience on the part of your lordship by the other party, my lord, may I pray that my lord, matter may be listed on 15, my lord.
15.
My lord. Or earlier 15, earlier than 15, my lord.
No, up to her, whether she will be able to
Earlier than
produce it.
15 won't be.
On 12, my lord, or my lord, on 11. I'm sorry, 15 is Sunday, my lord, Sunday, my lord. I'm sorry. On 12, my lord.
12.
It is nearby only, my lord. The record has to be called from the PSQ.
Okay, okay. Heard Mr. M. Kato, learned counsel for the petitioner, and Madam Ite, learned additional government advocate for
Can it be
the.
on 13th if it is Friday also? Because Lordship, today,
Okay, okay.
today is already done.
Okay.
Tomorrow I'll have to communicate.
On 13.
Tomorrow, tomorrow.
My lord,
For the
difficult.
state respondent. Heard in part, lays the matter on
13th.
12. Let us try 12 on
Yes, if it comes, we'll
12.
have it on 12.
Otherwise 30.
Yes,
My lord, 12, my lord.
Mm.
It's because my lord, as I see, my lord, recently my wife died, my lord. I am now with my lord. Even I'm not in a position to survive myself. Even my lord, give my lord the education
That's
to
all right,
my
but the service appears to be
Yes.
serious.
my lord.
You have assisted in one person from escaping from the jail.
Correct, my lord. This is the allegation of the my lord.
Certain position, Lordship,
Right.
this.
However, my
Certain
lord,
legal position that.
Then,
Disciplinary.
that's all right, but supplying this hacksaw blade for cutting the iron rod and supplying this
Uniform
liquor, uniform, etc. These are serious.
my lord, admittedly, my lord. My lord, another limb of submission is, if my lord, just for a moment, my lord, another limb of my submission is the officers who my lord terminated or my lord discharged, dismissed me from the service is my lord having no jurisdiction, my lord. That is another contention.
Having
No jurisdiction, my lord. I was appointed by the my lord some officer,
the person who discharges you.
my lord. That
That's
is my second limb of submission, my lord.
That's it.
My lord, as per the Arunachal Pradesh police my lord, rules 1999, my lord, they have quoted. As per that, my lord, only my appointing authority is the my lord, disciplinary authority who can my lord, dismiss from
Disciplinary authority and discharging authority are different.
my lord.
Then who discharges you?
My lord, the higher than my lord, the authority, my lord.
Higher than the
My
authority.
lord, deputy.
Where is the bar?
My lord, as per the they have prescribed. That is my affiliate authority, my lord. If my lord,
Appellant authority.
affiliate authority. If my lord, if I am dismissed, I have
Then
to
you
go
have
to
file appeal.
yes, I have to file. I have to file appeal before him, my lord. But
That's it.
in this case, my lord, the person.
That rule is available with you.
Yes, my lord. That rule is available. I have quoted in the petition also.
Let us see.
It is in my affidavit also, Lordship.
Okay.